Beginning Ulovarnani.
May please, your lordships.
Yes.
Item number 52.
50?
52, your lordship.
That matter pertaining to selection of.
Selection and appointment, your lordship.
We'll consider. We have come in, we'll consider. We'll hear you.
No, my lord, I'm not well today. I am suffering.
We'll take it up as the first item. Don't worry. First item. We'll take it up as the first item. You be here. Yes. 3-0. Yes, what happened? Why? Item number 30. That A&M worker, date of birth 6457. What is here? We'll take it up on Thursday. On the prayer of Miss A. Devi, learned. D. Bora, learned. Every day I confuse. D. Bora, learned. Standing Council, Health and Family Welfare Department. Registry to list this matter again on on 14/11/2025.
There is an interim order, my lord.
Interim order to continue till the next date of listing. You prepare your matter nicely.
I'm prepared, my lord.
You're prepared? Okay. Yes, Mr. Oh. $62. This is pertaining to those Nunmati. You were supposed to produce that. Mr. N. Borua, Learned Standing Council, IOC, prays that he be granted a week's time to. I know. A week's time to file an affidavit in the matter. 2 weeks' time to file an affidavit in the matter. Also, prayer is not objected to by the Learned Council for the petitioner. A registry to list this matter again on. Upod likhiba takotha. Mr. N. Borua, Learned Council for the Learned Council has entered. Learned Standing Council, IOC has entered appearance on behalf of all the respondents. Accordingly, service is complete. Because you have not filed a wakalatnama. Service is complete. Tar pishat baki kini likhiriba. So registry to list this matter again after 2 weeks on a date to be fixed by. Interim order passed earlier to continue till the next date of listing. Done? Yes, Mr. Dega.
Item number 16, my lord.
1-6.
Yes, my lord. Petitioner has received whole amount, my lord, so I may be allowed to withdraw, my lord.
Mr. P.K. Deka, this is that Nolbari matter.
Yes, my lord. Yes.
Mr. P.K. Deka, Learned Council for the petitioner, on instruction submit that the retired benefits of the petitioner has been released to him in full. Accordingly, he submits that the matter has been. Accordingly, he submits that he be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Council for the respondents. Accordingly, the writ petition stands dismissed on withdrawal.
Safely obliged.
What happened? Elder brother means certain Chaudhary, sir. 26. Gratuity. That whether the dearance allowance would be a part of the. How will it be? But you have a special regulation for yourself. That says after 15 years plus 30 years, you will have plus some amounts. But the appellate authority has given a detailed finding on each and every aspect. Other. Okay. A prayer is made on behalf of Mr. M.K. Chaudhary for an adjournment in the matter on the ground that he is in bereavement. Senior counsellor, he is in bereavement. Registry, full stop. Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter after 3 weeks on a date to be fixed by it. But here the steps have not been taken on 4 and. Okay, if there is none appearing, we will dismiss it for default. Then he'll come. Then we will see. But there was an additional affidavit filed in the matter recently. Who has filed that? You have filed that. Last time nobody appeared. We'll dismiss it for default, then he will come and take steps and all. You need not, if you're not appearing, you don't appear.
Mayor, please, Lordship. Item number 51 of the Delhi. Like to withdraw the matter as the matter has become infructuous.
That is the undertaking you gave before the registry. Okay, your name?
B.D. Kakoti.
You're not there. Oh, B.D. Kakoti, learned counsel for the petitioner. On instructions, submit that the petitioners do not desire to pursue this matter and accordingly prays that he be permitted to withdraw the writ petition. Any interim order? The full stop. In view of the above, the present writ petition stands dismissed on withdrawal.
All right, sir.
Yes.
For the petitioner in this case.
Oh, we give the consent, not consent. We are this matter was adjourned that you will file an additional reply, affidavit reply. They'll file. You are for Mr. This was pertaining to what was the issue?
I was allowed in my favor to create a post of head assistant in the not take any steps.
You retired in the meantime.
Yes.
You retired in the meantime.
Died.
He died in the meantime. Now the wife had made an application. Yes, a wife had made an application that was processed, but that was not taken to its logical point. A contempt is also there. Mr. A.K. Ghosh, learned counsel appearing on behalf of Mr. S. Dr. Standing Counsel, PNRD Department, P. Roman Anna, RD Department, prays that he be granted a week's time to file his response in the matter, right? So, prayer accepted. Registry to list this matter again on 19/11/2025. Also, 21/11/2025. Also, the respondents to file their response in the meanwhile. Also.
Can I please, Your Lordship?
Hmm.
I beg to mention item number, file an additional regarding some subsequent development.
What subsequent development?
Lordship, my senior,
Get him. We have been hearing this matter. This matter has been roaming around like a ghost. So I think we'll have to give it a closure today. Only ask your senior whether you have submitted your final bills. Right? Then we will ask the thing. If the final bills have been submitted, the matter has been taken care of. That's the end of the matter. Ask your, be here when the matter is called up. Yes.
Lordship, back to item 121.
20.
21, Lordship.
21. No adjournment.
Yes, Lordship.
No adjournment. Make your submissions. 2014. Today, this is 2025. Show me a law that a compassionate appointment can be given even after 11 years. This is State of Assam. Okay, APDCL. They have given a reason in the sorry. Be here when the matter is called up. We are disposing it of today. You satisfy me, I'll pass the order in your favor. Yes.
Your Lordship, I beg to mention item number 24. In this case, AC Borbar Learned Senior Counsel is appearing. He have some personal difficulties. So, Lordship can adjourn the matter. We have taken the consent of the other side also.
They have not passed any final order in your matter. Why? You have retired.
Yes, recently retired.
Retired. This was with regard to suspension, that is gone. Now, the challenge to the proceedings may not be maintainable because there is material against you. Now, they have completed the inquiry. Why are they not passing? This is that POSCO case.
Yes.
Yes,
Criminal
why are
case
they not passing?
Initiated against him, yes.
Okay. A prayer is made on behalf of Mr. A.C. Borbora, Learned Senior Counsel, for an accommodation in the matter today, for an adjournment in the matter today on account of his personal inconvenience. Prayer is not objected to by the Learned You have informed the other side?
Yes, yes.
Standing Counsel, Excise Department. Accordingly, registry to list this matter again on 19/11/2025.
Your Lordship, interim is there.
Interim order to continue till the next date of listing.
Obliged.
Please, Your Lordship. 5, Lordship. Counsel Mr. P. Vora is the youngest counsel, Lordship. Today morning, he had to go to Nagaon because of his mother's illness, Lordship. He had asked us to pray for day.
Only today. Okay. On the prayer of the Learned Counsel for the petitioner, a prayer is made on behalf of Mr. G.C. Bora for an accommodation in the matter only for today. Full stop. Full stop. On account of personal inconvenience, comma, full stop. Accordingly, registry to list this matter again on 17/11/2025. They are not filing any reply. Ms. M. Bhattchaji, Learned Counsel for the respondents, shall produce the enquiry file wherein the enquiry proceedings are available on the next date of listing without fail. In the event the file is not so produced, the officer who had conducted the enquiry shall remain present in person before this court at 10:30. Madam, I just want to see the manner in which the enquiry was done. Right? The charges only for with regard to, I think, that you did not join. I want to see how the charge was proved against him in the inquiry. That much only. Because the inquiry report says that they had a cup of tea, talked to him, and then passed the inquiry. That cannot be. There has to be evidences. There has to be evidences adduced to your witnesses. Otherwise, an inquiry is a farcical one. 17. Right. 17 this one? 17/11. Yes.
With the consent of the other side, I would like to mention item number 19. Outstation counsel is against this matter.
Yes.
Outstation counsel is engaged in this matter, but he couldn't be here due to some personal difficulty.
Ask him to come online. We'll hear him online. Okay. Ask him to come online. This is with regard to regularization of your contractual appointment. We'll hear him online. Ask him to come online.
Thank Your Lordship. I may be allowed to correct the reply affidavit filed by the petition.
It is that matter pertaining to the oil or ONGC employee transfer. Okay. And, forget it. You argue the matter when it is called. No need to make these corrections. We'll accommodate you, but argue this matter when the matter is called up. Just show me your right. That's all. Mr. Das has already heard it. Mr. Das has heard it. He has understood. He will make his submissions.
But in that, my lord, reply, my lord, that annexure 13.
Okay, whatever it is, we'll consider it. Don't worry. Those are small technical things. You come to the meat of the matter. Yes.
Your Lordship, regarding unpaid retirement dues, Lordship, as per the last order, Honorable Court has directed the respondent to pay the amount, but till date, no payment has been made.
Okay, let the matter be called up. We'll see.
The senior is out of station, Lordship.
When did he go out of station?
Okay.
Today. Okay, we'll see what Mr. Goswami says. You be here when the matter is.
Matter on 13.
Madam, I'll not pass any order which will cause prejudice to you. Okay? But this matters, it's not for fun that it is listed. There has to be something. Let the respondents appear, we'll see what can be done. You be here. There are orders passed by this court directing them to at least release 50%. They have undertaken, they have not done it. So let us see what can be done. Your presence of your senior may not be required. If I have to dismiss it, I'll do it in his presence only, right? But for allowing it or something, I don't require his presence. Your presence will do. Be here when the matter is called. Yes. Madam, you are appearing for? Mr. Chaudhary,
My lord.
your only grievance here is that a OBC candidate was appointed and a general candidate was overlooked. That's the only grievance. No other lacuna. No other lacuna. Show me. Where is the bar? Madam, where is the bar? When a post is advertised without any reservation, where is the bar for
No,
a
your
reserve
lordship-
community candidate to appear?
You will peruse the advertisement.
I'll peruse it.
Page 13, your lordship.
Yes.
Page 13.
Huh.
There is serial number 2, your lordship.
Kalzar.
Kaljar,
Hmm.
60.
Hmm.
Kaljar.
Center number 60.
Center number.
Huh.
Kaljar. Caste. ST,
Caste, nothing.
but Kaljar nothing.
Nothing.
That means.
That means open for all.
Whether it is ST, SC, general. They
Sir,
have
you are a general community
Please,
candidate.
Lordship will see. But others are mentioned. Why not in that, in
Okay.
that case is not
Okay,
mentioned?
okay, I got it. Anything else?
This is the only.
Only.
That
Yes,
may be-
madam. I got it. Heard Mr. R.M. Chaudhary, Lanark Council for the petitioner. Also heard Miss. You are appearing as?
And as well as I am also local candidate, my lord. He is not the local candidate.
That you have not pleaded.
My lord.
That you have not pleaded in your writ petition.
My lord, I have pleaded.
Where? Show me.
I have pleaded, your lordship.
Where you have pleaded? Show me. You are appearing as SC BTC. Also heard Miss B. Bhuya, Leonard, Standing Counsel BTC, appearing for the respondent's number. Respondent number 3, only 3. 4, 5. Madam naam likha, Miss M. Bachaji, Leonard, additional senior government advocate, appears for the respondent number 1 and 2. 3, 4, 5, Bhuya. The petitioner, by way of instituting the present writ petition, has presented a challenge to the selection and appointment of the respondent number 6 herein as Anganwadi worker of Kalzar number 3 Anganwadi Center, bracket center number 60, bracket over, under Tihu-Boroma ICDS project. Fuso, the challenge to the Fuso, the petitioner in the present, a petitioner has assailed the selection and appointment of the respondent number 6 on the ground that the advertisement dated 11/7/2022 issued in the matter, if issued for recruitment against the post, against the issued for engagement of eligible candidate as Anganwadi worker of Kalzar-3 Anganwadi Center, had not specified that the post in question would be reserved for any of the reserve community candidates. Accordingly, it is projected that the post was advertised only for general community candidates. First up, Mr. Chaudhary, by referring to the materials brought on record, has submitted that the respondent number 6, being a candidate belonging to the other backward class, was not eligible for applying for recruitment for applying against the post in question in pursuance to the advertisement dated 11/7/2022, and the recruitment process was required to be limited between the candidates belonging to the general community. Full stop. Ms. Bhuiya, B. Bhuiya, learned standing counsel. BTC has disputed the above position and has submitted that the advertisement has not reserved the post in question for any of the reserve community candidates, it was open for all for candidates belonging to all communities to apply for recruitment against the same. She further submits that in the selection process, the respondent number 6 having scored more marks than that of the petitioner herein, and the said position not being disputed, she submits that there is no error, that no error was committed by the authorities in selecting and appointing the respondent number 6 as an Anganwadi worker against the post against so and so Kaljar, number 3 Anganwadi Center. I've heard the learned counsel for the parties and also perused the materials available on record. So the advertisement dated 11/7/2022, insofar as it concerns Kaljar number 3 Anganwadi Center, no post the Anganwadi Center, the post was not reserved for any reserve community candidate. Also, in that view of the matter, the court cannot contemplate that the post in question is only required to be filled up by considering only the candidates belonging to the general community. First of all, the position of law, settled position of law is that when a post is advertised without there being any reservation indicated against the same, the said post is open for recruitment amongst candidates belonging to all communities, both general as well as reserved. First of all, accordingly, the respondent number 6 was well within her rights to apply in pursuance to the advertisement dated 11/7/2022. First up, having noticed the above position, this court finds that the respondent number 6 in the selection process had scored more marks than that of the petitioner herein, and the same is revealed from Annexure 5 appended to the annex to the writ petition. First up, the said position is also not disputed by the learned counsel for the petitioner. First up, in view of the above position, this court, noticing that the challenge in the present proceeding is only to the effect that the respondent number 6, being a candidate belonging to the OBC community, could not have been permitted to appear in the recruitment process in pursuance to the advertisement dated 11/7/2022 for engagement as Anganwadi worker in Kaljar number 3 Anganwadi Center, this court having already concluded that there was no bar for a reserve community candidate in applying in pursuance to the advertisement dated so and so 11/7/2022 for recruitment against the post of Kaljar number 3 Anganwadi Center, and further, this court having also noticed that the respondent number 6 had scored more marks than that of the petitioner herein, this court is of the considered view that the contention raised by the petitioner in the present writ petition would not mandate an acceptance. First of all, accordingly, the writ petition subpara is held to be devoid of any merit, and the same stands dismissed. However, there would be no order as to cause.
Peruse the paragraph 6 you paragraph 6.
Fine. Anything is there, Mr. Chaudhary, please. You know your rights.
Not anything, the appointment of.
No. Already, a full stop. It is already noted that it may be noted here that the respondent number 6 has already been appointed, and this court, in view of the challenge made in the present proceeding, has not interfered with this.
she obtains.
If somebody, there is a lady before that, if she challenges, that will be a different challenge altogether. I'm sorry, Mr. Chaudhary. Yes.
Kindly pass over the timing, Lordship. My senior.
I've heard this matter. I have only to pass an order only. After some time. When Mr. Sigdar is here, kindly
Yes,
inform.
Lordship.
May I please, your Lordship? Lordship, on the last occasion, they had shown a letter wherein we had stated that we will withdraw the cases. Lordship, that letter was given in pursuance to a meeting held with the of Road, Train, Transport, Highways, Central Government, my lord. Thereafter, the was held with the state government chief engineer PWD, where it was decided that the contractor, that is the petitioner herein, shall be paid 14 lakhs in relation to the present work in question, Lordship. And thereafter, we will withdraw all the cases. Lordship, no payment was made to us. So, Lordship, we did not withdraw the case. So, Lordship, 2 weeks' time may be granted to me to file the additional affidavit bringing these.
We have heard it from you. That is enough. Yes, Mr. Nayak.
Power. Maybe withdraw the case.
But he says that there is a stipulation that it will be withdrawn after payment of 14 lakhs.
Lordship.
Then, if that is an agreement reached between you, why should we permit him to withdraw this without fulfilling that agreement? What happened to the final bill? And see, the condition that is there, it mandates that if the work is beyond 24 months, you will allow him the escalation and you will withdraw that money, escalation amount paid for the first 24 months from the final bill. Right? That is your agreement. How can you violate that agreement? Because you have started from the running bill itself. You cannot. Well, then he says that there is a further stipulation that you will pay, then he will. Where is that? Show me.
Lordship,
No problem.
first para, last 4. Held with the Ministry of State, central government. Road. That we will withdraw and payment will be made.
You withdraw, then the payment would be made.
Lordship, a tri-party agreement has to be entered.
Where is that? That has not been
No,
entered in.
No, Lordship. That is why I want to bring this on record, your Lordship. This and minutes with the state government as well.
Where is the minutes of the state government? What is this 80?
Arbitral tribunal, man.
The matter was given to the arbitrator.
Lordship, no, DRB order was passed.
Then they said that
they
they
did
will
not
be.
approach the arbitrator. with the
Had the
stipulation.
arbitrator been appointed here?
No, Lordship. They had given us a letter, but that was done after the expiry of the stipulated time. So the acceptance was not done by the contractor.
What is the letter dated of the central government?
2020.
26/6/2020.
Lordship. He had given them the letter in 2021, Lordship. Thereafter, recent letters.
This whole thing is pertaining, Mr. Nayak, to this work, or there is some other works also.
No,
This work.
Single work. Lordship, these are the recent letters we have given them to.
What is this judgment of this court in 5/8/2019?
Separate writ petition, not related to.
What was that for? Same issue.
Documents were handed over to me. I'll file the affidavit within 2 weeks and thereafter within 1 week.
Mr. M. Sahewala, learned counsel, appearing for the petitioner, submits that he would be required to file an additional affidavit in the matter to bring on record materials demonstrating the manner, bringing on record documents demonstrating the manner in which the claim of the petitioner was processed by the respondents. Also, it is to be noted that the Mr. P. Naik, learned additional advocate general, appearing in this matter on behalf of the respondents, had submitted that the petitioner on a agreement arrived between the parties had undertaken to withdraw the present writ petition. Full stop. The said position is disputed by Mr. M. Sahewala, and he submits that the additional affidavit, that the documents that would be brought on record in the additional affidavit would clarify the position. Full stop. In view of the above, the petitioner is granted time till 24/11/2025 to file his additional affidavit in the matter. Full stop. Thereafter, the Mr. P. Naik, learned additional advocate general, shall complete his instructions in the matter. Full stop. And apprise this court of the stand of the respondents. Accordingly, registry to list this matter again on 3/12/2025. Take it equally. Please take it back.
Item 8 may be taken up first, no? Ordinary benefit we see,
Oh, we'll take both together.
and my lord, then
What is that difference in 7?
he already retired, my lord, he is claiming.
You show me from your prayer that you are claiming your seniority,
That is,
promotion. You're not going to get it. You're not even made a prayer for that. So basically, your case is that you have been given your pensions at a lower stage. Further, you say that your pay has been fixed at a lower stage. That's the only thing you have, nothing more. So your prayer of promotion is not maintainable, because you check up and tell me if there is a prayer there.
my lord.
No prayer.
Subsequently, I was engaged in this case. I am.
That will not
No,
make it something
But,
else.
from instruction of my client, my lord, the other item number 8, that is regarding his pension, my lord. Similarly, he has been low pension, my lord, less pension.
Understood it. What is the reason for that?
That, my lord, I want to.
You do it both together, because both are interconnected. Because pension by itself will not come up, because it is a problem which is there from your service period, which led into that pension being fixed at a lower stage.
Lordship will please to take up item number 8, my.
I have taken up. You make your submissions.
I take that matter
Hmm.
first. My lord, basically, my lord, in that we are claiming revised pension, parity of pension when similarly situated employees given promotion and retirement at the within same time, my lord, they were paid more than the petitioner, my lord. And earlier there was a order of penalty, my lord, where that was challenged in before the. May I come to the order of penalty?
Hmm.
Case 23, my lord.
Hmm.
Case 23, this was the penalty, my lord.
Hmm.
Dated 23/5, 11 portion, page 24. where I have been, last two paragraph, my lord,
Hmm.
considering the whole circumstances,
Hmm.
is where I have been inflicted the penalty of demotion to lower post.
Hmm.
But while lower post of meter reader,
Hmm.
but while demoted, my lord, seniority of the petitioner was to be placed first.
You did not join back. You took leave.
It
You
was,
joined back only on 10/3/2006. Right? Then what?
was already approved,
Now
my lord.
tell me, Mr. Borua, what is the error made by them?
Yes, I'm coming to that,
Ah.
my lord.
Come to that directly.
Yes, my lord. Then your lordship will see page 26 is the earlier order of the Honorable High Court. Relevant portion.
There are two orders of the Honorable High Court.
First order, my lord, challenging the penalty.
That period, suspension period was directed to be considered.
That has to be
Then,
considered.
then this court again, my Lord Justice Singh, again directed that you could not have been paid, the period should be. Now tell me what is the error?
My lord, may I draw your lordship to page 29, my lord, of the High Court judgment, my lord. Relevant portion, my lord, last paragraph.
Hmm.
Page 29, my lord, the order of penalty was challenged. There, your lordship will page 29, last portion. However, that part of the impugn order which seeks discontinuation in service stands interfered with.
Hmm.
As per the impugn order dated 23/5/2003,
Hmm.
period of suspension of petitioner shall be treated a period of absence from duty and shall not be.
That has been interfered with.
That has been interfered with.
Then what?
Maintaining continuity in service. Then, my lord, your lordship will see, after that, my lord, I was been given page 31, have been given promotion that on only on 11/3/11/2011. And I have been superannuated on page 30.
December.
Yes. Now, your lordship, earlier, my lord, at point of time, court has directed them to produce a comparative statement regarding the similarity. Now, my lord, that was not produced by them, my lord, but in our reply, if your lordship will come for a moment,
Hmm.
we have annexed one document in our reply. My lord.
Page 76.
Yes, ma'am. Annex A, last page, my lord. Our reply, affidavit
Hmm.
reply.
Hmm.
That from there, your lordship will see
Hmm.
comparative statement.
Hmm.
Reply, my lord. I don't
Hmm.
have the, my lord, running page, my lord. Filed on March 2020.
Hmm.
Here your lordship will see on the day of suspension, my pay was higher, my lord.
Hmm.
That is Safdar Patwari column. Was
Okay.
8,000.
Mr. Borua, I've got it. Sit down. Mr. Chaudhary, why is the problem arising? See, he was placed under suspension. There is a period of suspension. Then that suspension was revoked. You revoked it by regularizing it, said that he will not be entitled to any pay for. That will be diced now, literally. And then he was reverted. He was asked to join. He did not join. He was on leave. That whole period of leave was regularized. He finally joined on 10/3/2006. In the last order of this court said consider the whole period. Now you have, because the order of penalty says that his pay would be fixed at the last stage. Last stage. So why was this fixed on 10/3/2006 and not on the day when he was imposed with the penalty? If he is imposed with that, he gets the increment, his pay goes up. No salary would be given to him. But as on 10/3/2006, his pay has to be fixed considering the whole period. If you do that, this matter gets resolved. You come to page 72. Internal page 7 of your affidavit. Second case. So 6490 is the end stage. Right? This is an additional affidavit. Got it? So this 6490 ought not to have been on 10/3/2006. It ought to have been on the date he was reverted. If that is done, he gets everything. He'll get stagnation agreement. And then the fixation will come from 1/1/2006. He gets everything. Mr. Borua, that is your case. Got it? We are passing that order. Do the calculation, give it to him. But Mr. A.K. Borua, learned counsel, B. Borua, WPC 1338, no, WPC 7561/2008 and WPC 1338/2020. Heard Mr. B. Borua, learned counsel for the petitioner. Also heard Mr. B. Chaudhary, learned standing counsel, APDCL, appearing for all the respondents. Learned counsel for the petitioner in the above noted writ petition, and Mr. B. Chaudhary, learned standing counsel, APDCL, appearing for the respondents in the above noted writ petitions. First, the above noted writ petitions being instituted by the petitioner and involving issues which are common, both the writ petitions were taken up for hearing analogously and is being disposed of by this writ petition. First, the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. Also, the petitioner who had joined his services as a meter reader was subsequently promoted as a senior meter reader. Also, while serving as a senior meter reader, the petitioner herein was subjected to a departmental proceeding. First, on conclusion of the departmental proceeding, the disciplinary authority wide order dated 23/5/2003, imposed the penalty of demotion to a lower post upon the petitioner herein. Full stop. Accordingly, the petitioner was demoted to the post of meter reader with full stop. The disciplinary authority wide the order dated 23/5/2013 further stipulated that on being demoted, the seniority of the petitioner herein would be placed first amongst the incumbents in the cadre of meter reader, and however, he would be eligible for promotion to the post of senior meter reader only on completion of 5 years satisfactory service. Also, it was further stipulated that on his such reversion, the pay of the petitioner shall be fixed at the maximum of the time scale as authorized to the post of meter reader. Also, in pursuance to the said order dated 23/5/2003, the petitioner herein was reverted to the post of meter reader. However, he had not joined his services and was on leave. Full stop. The petitioner ultimately joined his services on 10/3/2006. Full stop. It may be noted that the petitioner had presented a challenge to the order dated 23/5/2003 by way of before this court by way of instituting a writ petition being WPC number 4598/2003, and the coordinate bench of this court wide order dated 24/10/2011 had negated the said challenge. However, in the said order, it was provided that the continuation in service of the petitioner shall be maintained even for the period of suspension, and the period shall count towards pension. First of subpara, the petitioner thereafter, on completion of 5 years of service, with effect after pursuant to assumption of charge after his order of reversion, that is with effect from 10/3/2006, was promoted to the post of senior meter reader with effect from 12/10/2011, wide an order dated 3/11/2011. Also, the petitioner thereafter, on attaining the age of superannuation, retired from his services with effect from 31/12/2011. Full stop. Subpara. The petitioner at this stage had instituted WPC number My Lord Justice NK Singh's order.
Page 35 below. Second read petition.
Had instituted WPC number 1172/2008, seeking parity of pension. This court, the coordinate bench of this court, wide order dated 9/5/2019, proceeded to dispose of the said writ petition by directing the respondent authorities to treat the entire period of leave for the purpose of fixing the pay scale and consequently the pay scale of the petitioner in the grade of senior meter reader be rectified. First off, it is seen that in pursuance to the directions passed by this court-wide order dated 9/5/2019 in WPC number 1172/2018, the respondents had fixed the pay of the petitioner herein, and accordingly, the pension of the petitioner was also revised and his arrears were released to him. However, the petitioner instituted, however, first, in pursuance to the said developments, the petitioner approached this court by way of instituting WPC number 7561/2018, inter alia, praying therein for being granted this appropriate scale of pay on his reversion from the post of senior meter reader to that of meter reader. Also, the petitioner had also assailed the order dated 23/5/2003, that is the order of the disciplinary authority imposing upon him the penalty of dismissal from service. However, Mr. B. Borua has fairly submitted that the said order is not being pressed. Said challenge is not being pressed by the petitioner herein. First off, during the pendency of WPC number 7561/2018, the petitioner has again approached this court by way of instituting WPC number 1338/2020, inter alia, praying therein that the pension and pensionary benefits of the petitioner be authorized to him by maintaining parity with the similarly situated senior meter readers who were promoted to the post of senior meter reader along with approximate to the time when the petitioner herein was so promoted. First of all, this court has considered first of all, I've heard the learned counsel for the parties and also perused the materials available on record. First of all, the facts as noticed herein above is not disputed. First of all, it is to be noted that the petitioner on being imposed with the penalty of demotion to the lower post, that is to the post of meter assistant, the disciplinary authority had stipulated that the pay of the petitioner would be that the pay of the petitioner would be fixed at the maximum of the scale of pay authorized at the relevant point of time, to the post of meter reader. First of all, the petitioner was wide order dated 31/5/2003, released from the post of senior meter reader, and he was directed to join against the post of meter reader in the establishment of the existing executive engineer, Sonapur Electric Subdivision. First off, it is seen that the petitioner thereafter had not resumed his services and had remained on leave with effect from 1/6/2003. First off, till 10/3/2006, when he had actually assumed the charge of the post of meter reader in pursuance to his order of demotion. First off, What is to be noted in the present proceeding is that the respondent authorities, by passing an order dated 26/3/2007, had regularized the leave of the absence of the petitioner as leave by granting to him earned leave, commuted leave, half average pay leave, and extraordinary leave. Accordingly, the period of absence of the petitioner from 31/5/2003 to 9/3/2006 stood regularized. First up, the grievance of the petitioner that he was authorized his pay and allowances at a lower stage than that authorized to persons holding the post of meter reader along with him at the relevant point of time, and also that he was authorized his pension and pensionary benefits at a lower stage is clear from the contentions raised by the respondent authorities in an additional affidavit filed in the proceedings of WPC number 1338/2020. The respondents in the said affidavit have contended that after the order was passed by this court, the petitioners was passed by this court in WPC number 1172, Justice N.K. Singh's order,
Yes, yes.
1172/2018, the pay of the petitioner was refixed at the stage of rupees 6490 in the pay scale authorized to the post of meter reader only with effect from 10/3/2006. Also, the error had occasioned in the with regard to the date of effect given to the refixation of the pay of the petitioner. First up, in terms of the directions passed by this court in the earlier writ petitions noticed herein above, the period of suspension of the petitioner is also to be reckoned as to be in service. First up, thereafter, the petitioner having been demoted to the post of meter reader with effect from 31/5/2003, his pay in the post of meter reader is to be fixed not from 10/3/2006 but from 31/5/2003. First up, however, the petitioner herein would not be entitled to any pay and allowances for the period of with effect from 31/5/2003 to 10/3/2006, accepting the pay which would normally be available to him on account of the nature of the leaves granted to him. Also, they said exercise not having been carried out by the respondents herein, a grievance has arisen with regard to the lower not taken the exercise, the petitioner was required to approach this court by way of instituting the above noted writ petitions praying for parity with regard to his pay as well as pensionary benefits. Full stop. This court is of the considered view that in the event the respondents are directed to refix the pay of the petitioner on his reversion with effect from 31/5/2003 in terms of the order dated 25 penalty order 23/5/2003, the grievance of the petitioner herein shall be stand redressed. First up, in view of the above, the respondents, more particularly the respondent number, the respondents are directed. More particularly, the respondent number 2 is directed to refix the pay of the petitioner in the post of meter reader with effect from 31/5/2003 in the pay scale as authorized to the set post at the relevant point of time, and thereafter by taking into consideration the pay scale coming into force on a revision of pay being effected, fix the pay of the petitioner as on 10/3/2006. First up, the areas of pay with effect from 10/3/2006 occasioning on account of the said refixation be released to the petitioner within a period of 2 months from the date of receipt of a certified copy of this order. 2. The petitioner herein, although being directed to have his pay refixed with effect from 31/5/2003, would not be entitled to any salary, any area salaries with effect from 10/3/2005 to 31/5/2003 to 10/3/2006, accepting the pay which he would be entitled to on account of the nature of the leaves granted to him. Full stop. On his refixation of pay as on 10/3/2006, the respondents having would thereafter calculate his pay as on the date of his promotion to the post of senior meter reader, which with effect from that was 10/11 or something. How much it is? What was the date? 12/10/2011. Full stop. And also release him the areas thereof. Full stop. The revision of pay now directed to be carried out in the matter in terms of the directions passed herein above would also mandate a revision of the pension and pensionary benefits of the petitioner. Full stop. The respondent authorities shall carry out the revision with regard to the pension and pensionary benefits basing on the pay that would now be authorized to the petitioner on the date of his superannuation after carrying out the revision as directed herein above. Full stop. The areas of pension and pensionary benefits due to the petitioner be released to the petitioner within a period of 6 months from today. With the above observations and directions, the writ petition stand disposed. Anything more is required? Full stop. Why, it is to be noted that the areas now working out shall be paid to the petitioner after deducting the amounts already paid in terms of the earlier revision carried out in his matter by the respondent authorities. Done with?
Reply, sir, deeply reply.
Item 5.
Please,
Yes, Mr. Signar, how can we help you?
my lord, I am relying on a judgment of Supreme Court.
Yeah, please.
That judgment goes to show that mental health disorders, he may be accommodated in alternative. Paragraph, I have marked paragraph 997 and final conclusion is in 7. Then, my lord, 107 is the final conclusion.
Anything more, Mr.
My lord.
Signar? This one? The Persons with Disabilities Act 2016 to be. La. Heard Mr. A.R. Sigdal, learned counsel for the petitioner, also heard Mr. B. Deka, learned CGC, appearing for the respondents. The petitioner, by way of instituting the present proceeding, has presented a challenge to an order dated 8/8/2015, by which his services were where is that order, impugn order? Was
Yes,
terminated,
46.
invoking the provisions of Rule 6 of the Central Civil Service (temporary service) over Rules 1965. '65. Huh? Huh? Uh-huh. 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 Right. So the petitioner has also assailed an order dated January 2006, passed by the Inspector General, Southern Sector, CRPF, rejecting the appeal preferred by the petitioner herein against the order of his termination dated 8/8/2015. First, the facts in brief requisite for adjudication of the present writ petition is noticed as under. The petitioner, in pursuance to a recruitment process, was selected for appointment as constable (general duty) in the Central Reserve Police Force hereinafter referred to as the force. Also, the petitioner on his such selection was appointed as a constable, wide order dated 16/11/2013. Also, the petitioner was thereafter deputed to undergo training. Also, thereafter, the petitioner was then reported to undergo basic training at the Regional Training Center, Latur, on 17/5/2014. So the petitioner, after reporting at the Basic Training Center, absconded from the remained absent from the training with effect from 19/5/2014 and had reported back on 3/9/2014. However, the petitioner was allowed to continue with his training, but he again had to remain absent on account of being sick with effect from 29/9/2014 to 6/10/2014. The petitioner during the said period of time was detected to be suffering from lumbar disc disease with nerve compression. The petitioner remained in the hospital. The petitioner was admitted to the hospital by the authorities of the training center, and he remained in the hospital with effect from 7/10/2014 to 13/10/2014. On returning from his medical leave, the petitioner was found to be sitting alone, not talking to anybody, and was seen to be under stress. Due to the unusual behavior demonstrated by the petitioner herein, the petitioner was referred to the psychiatric ward of the GMCH, Latur on 2/12/2014. The petitioner, on being evaluated, was found to have persistent feeling of helplessness, worthlessness, decreased sleep and appetite, and was demonstrating withdrawal behavior for last 2 years. He was also found to have loss of interest in daily activities, suicidal attempt in past and was diagnosed as suffering from apostrophe without major depressive disorder and accordingly was put under medication. Also, Sapper, the petitioner's condition not being found to be improving, he was referred to the composite hospital, CRPF, Avadi for treatment, for further management. Also, the specialist examining the petitioner at the composite hospital, CRPF, Avadi, had again diagnosed the petitioner to be suffering from major depressive disorder. Also, accordingly, on the basis of the evaluation of the petitioner by the expert at the said hospital, the petitioner came to be declared to be unfit for training and service as a combatant in the armed forces, and he was categorized to belong to shape 5 bracketed P and was recommended for invalidation from service. Full stop. Accordingly, the competent authority on examining the opinion submitted in the opinion furnished in the matter by the specialist from the said hospital, proceeded by the order dated 8/8/2005 to terminate the service of the petitioner by invoking the provisions of Rule 6 of the CCS bracket temporary service bracket over Rules 1965. So, the petitioner being aggrieved by his termination, by referring to the reports which he had subsequently obtained from private institutions as well as government institutions, approached by preferred an appeal in the matter before the concerned authority. Full stop. The appellate authority thereafter, on consideration of the appeal, wide order dated 16/2016, proceeded to reject the said appeal by holding the same to be devoid of any merit. Full stop. The petitioner accordingly has instituted the present proceedings. Mr. A.R. Sigdar, learned counsel for the petitioner, after taking this court through the facts noticed herein above, after reiterating the facts noticed herein above, has referred to opinion given in respect of the ailment suffered by the petitioner by the doctors, by the specialists of National Institute of Mental Health and Neurosciences, wherein it was opined that the petitioner was fit to resume his duties. Full stop. He further refers to the, where is that Guwahati Medical College?
My lord, at page, last page, my lord, 53.
Huh?
53.
He further refers to opinion given in respect of the petitioner by the doctors, by the experts, by the doctors of Guwahati Medical College and Hospital on 21/12/2015, which reflects that the petitioner's mental state does not reveal any psychiatric illness. First, basing on the said opinions, as well as the fact that the petitioner who was, as well as by contending the petitioner who may have suffered from a depressive disorder at the relevant point of time, had fully recovered therefrom and eligible to be continued in his services, Mr. Sigdar submits that the impugned orders would require mandate and interference from this court and a direction with a further direction for a reinstatement of his petitioner in his services and with all consequential benefits. Anything more, Mr. Sigdar? This one, look. Also, Mr. Sigdar has also made an alternative argument referring to the decision of the Honorable Supreme Court in the case of Ravindra Kumar Dhariwal and another versus Union of India and others, apostrophe, order dated 17/12/20, the judgment dated 17/12/2021, passed in civil appeal number 6924/2021, and has contended that in the event, even if it is considered by this court that the petitioner was suffering from mental ailments, the respondents are required to be directed to consider the case of the petitioner for an alternative appointment. Mr. B. Decca, learned CGC appearing for the respondents, has submitted that the petitioner's health condition having been examined, having been diagnosed the petitioner while undergoing his training, for the symptoms demonstrated by him, he on being sent for medical examination, having been diagnosed to suffer from moderate depressive disorder, and the medicines as given to him having not shown a response, the petitioner came to be referred to the Composite Hospital, CRPF at Avadi. Also, he submits that the specialist examining the doctor at the said Composite Hospital, having opined that the petitioner was suffering from moderate depressive disorder and he was unfit for continuation in the force, the opinion in details having brought on record the fact that the petitioner was not fit for being enrolled as a member of the force, the competent authority had wide order dated 8/8/2015 proceeded to terminate the engagement of the petitioner herein under the provisions of Rule 6 of the CCS (TS) Rules 1965, read with Rule 16 of the CRPF Rules 1955. He submits that the subsequent certificates as produced by the petitioner and brought on record in the writ petition on perusal does not reveal that the petitioner at the relevant point of time when he was terminated from his service was in fact not suffering from a depressive disorder. Also, he submits that the petitioner having been recruited for the duties of a competent, a person suffering from depressive disorder cannot be entrusted with arms and ammunition, which would be at the peril to the members of the force as well as the public at large. Accordingly, he submits that the respondent authorities had not committed any error in passing the order dated 8/8/2015 as well as the order dated January 2016 dismissing the appeal of the petition. I have heard the learned counsel for the parties and also peruse the materials available on record. The facts noticed herein above is not disputed by the parties. Full stop. The petitioner on being referred to the petitioner while undergoing his basic training was referred to the Composite Hospital at Avadi. Composite Hospital, CRPF at AVADI. First up, therein the authority, the specialist examining the petitioner and diagnosed the petitioner to be suffering from moderate depressive disorder. First up, the specialist thereafter, basing on the examination, on the evaluation of the mental condition of the petitioner, had submitted a detailed report on 19/3/2015, and therein he was and therein it was highlighted that the petitioner suffering from major depressive disorder, a major mental illness, characterized by remission and relapses with medication, aggravated by stress factor in service as well as in personal life, needs a continuous medication with emotional and social support, and accordingly, the petitioner was declared unfit for training and service as a competent in the armed forces. First up, his health condition was categorized as S5 (P) and recommended for invalidation in service. First up, basing on the said opinion rendered in the matter by the specialist of the Composite Hospital, CRPF, Avadi, the petitioner herein was after following the due process mandated, was wide order dated 8/8/2015 issued by the competent authority, terminated from his service under by invoking the provisions of Rule 6 of the Central Civil Service (temporary service) over Rules 1965, and the petitioner was also held to be entitled to claim a sum equivalent to the amount of his pay plus allowances due to him immediately before the termination of his services. Full stop. The petitioner in the present proceeding, in support of his contention and also to dispute the conclusions arrived at by the specialist at Avadi, specialist at the Composite Hospital, Avadi, CRPF, has referred to opinion rendered in his matter by the experts of National Institute of Mental Health and Neurosciences, dated 30/4/2015. First up, a perusal of the opinion rendered by the said doctors of NIMHANS, I got National Institute of Health, not a bracket or NIMHANS will here, would reveal that it was opined that the petitioner was fit to resume his services. However, it was further stipulated that the petitioner needed regular follow-ups. Full stop. The diagnosis as set out in the said certificate dated 30/4/2015 is that the petitioner was suffering from complicated grief disorder. Full stop. The petitioner thereafter has referred to a certificate issued by the doctors of Guwahati Medical College Hospital upon his evaluation. So the said certificate is dated 21/12/2015, and it reveals that the current mental state of the petitioner on examination does not reveal any psychiatric illness. So this court has perused the said certificates dated 30/4/2015 and 21/12/2015. So on a consideration of the said certificates, this court finds that the certificate dated 30/4/2015 issued by the NIMHANS authorities, having also diagnosed the petitioner to be suffering from complicated grief disorder, the opinion rendered in the matter by the specialist of the Composite Hospital, CRPF, Avadi, on 19/3/2015 would not mandate an interference, inasmuch as it is established that the petitioner was suffering from sudden mental ailments which would not have mandated his continuation in the force. Full stop. In the above factual backdrop, this court would now notice the aims and objectives of the Central Reserve Police Force. Full stop. The force is India's largest paramilitary force. Full stop. It performs a wide range of duties, for example, law enforcement, counterinsurgency operations, VIP security, etc. CRPF personnel are deployed all over the country for carrying out multi-dimensional duties. CRPF is known for its performance, discipline and commitment in maintaining peace and security of the nation. Full stop. The question that would now arise is whether the action on the part of the respondent, that is the authorities issuing the impugned orders, was justified or not, and if so, under what circumstances. First of all, as noticed herein above, the medical records of the petitioner brought on record, having disclosed that the petitioner at the relevant point of time was suffering from a mental ailment, and the same being of a nature which would not have permitted his continuation in the service as a combatant in the armed forces, this court would not second guess the said consideration as arrived at in the matter by the experts. First up, the mental ailment of the petitioner having been found to be of a nature which would not permit him to discharge his duties with utmost commitment and discipline, comma, this court also noticing that the petitioner would also be required to handle arms and ammunition, comma, with the nature of the ailment suffered by the petitioner, which again is demonstrated to be a ailment having phases of remission and relapses on with regard to the manner in which it is being managed, comma, would not be in a position to direct the respondents to reinstate the petitioner in his service. Full stop. In view of the above, this court is of the considered view that the termination of the petitioner vide the order dated 8/8/2015 would not mandate any interference. Such a course of action, such a conclusion has been drawn by this court, considering the nature of the ailment suffered by the petitioner as well as the need of as well as the manner of duties required to be discharged by the petitioner in the force. Force of. Having drawn the above conclusion, this court would now examine the decision relied upon by the learned counsel for the petitioner. So, this court finds that the said decision is based on an interpretation of the persons with disabilities bracket equal opportunity, comma, protection of rights and full participation bracket Act 1995. Also, no, by the Rights of Person with Disabilities Act 2016. Also, the said decision in the considered view of this court would not be applicable to the facts of the present case inasmuch as the said decision in the considered view of this court would not advance the case of the petitioner herein, inasmuch as the petitioner herein was terminated from his services during the stage of his training. The petitioner was not an enrolled member of the force at the time when he was terminated from his services. Accordingly, in view of the facts involved in the present proceedings, this court is of the considered view that the petitioner that the respondents cannot be directed to consider an alternative appointment to the alternative appointment for the petitioner herein, inasmuch as the petitioner had at the time of his termination from services not been enrolled as a member of the force. Further, he had not even completed his training for the said purpose. Full stop. In view of the above discussion, this court is of the considered view that the present writ petition is devoid of any merit, and accordingly, the same stands dismissed. However, there would be no order as to cause. Sorry, Mr. Thikdar. Yeah. Yes, Mr. Pugan.
Basically, we have challenged the decision of the application for voluntary filing an RTI application.
What is the basic requirement for consideration of a voluntary application? Basic minimum service.
20 years service, Lordship.
Have you completed 20 years service?
There is a break in service, Lordship, but
Forget it.
Lordship,
Have you completed?
completed, Lordship.
No. Qualifying service you have not completed. There is break-in service.
Break in service, yeah.
How can you? You have been terminated. After you are terminated, this prayer cannot be, you have not challenged the termination.
But, my was removed from service on the ground of unauthorized absence, Lordship.
Fine. What is the, you participated in the proceeding.
Perhaps not, Lordship. I have filed an additional affidavit.
Therein you have brought you have participated. There is nothing here. Police force, member of the discipline force, termination. What is the error? What is the error, Mr. Pugan here?
Perhaps, Lord, I was not given proper lordship
Perhaps that is enough to dismiss the writ petition.
from the record, lordship.
From the records, it's in that you were heard, you participated in the proceeding, you filed reply, you participated, but in your writ petition, there is nothing. Show me something which I can help you.
Lord, the only thing is that, Lord, during my service, lordship, I was suffering from
That plea, Mr. You have taken here only. You have not taken that plea before the authorities. Never have you taken. Show me you have taken that plea before the authorities.
I have made.
If you are suffering from lunacy, there will be some certificate. Extent of that. Show me that.
Only thing that I have made a statement that lordship.
Your statement will not do, Mr. Fukan. You will have to support that statement with material. Where is that material? Show me I am coming in your favor now only.
Not with me, may I?
Not
plead that
with me means in your, this writ petition is pending from 20.
lordship?
If last 5 years you could not bring it on record, we think that is, it's high time that we close this.
May I pray that lordship, if possible, lordship, let them file the record, lordship.
Report is here. Everything is here. Nothing more is required.
Whether I have filed reply or because that
Why should you? It's your headache. You bring it on record. You have taken that plea. Support that at least by a medical document. That yes, during this period, I went to Tezpur, Lokopriya Hospital, Institute of Mental Health Sciences. They have given me this certificate. Enough.
statement that
You statement, support it. Statement, anybody can make it.
my lunacy, lordship, I could not the record.
You no need. You get yourself, you should have got yourself examined, filed an advocate should have made the first endeavor that you have said that you are a lunacy. How can a madman say that he is lunatic? Can a madman say that he is mad? His family will say. You have not said that he is the only person, no family members. Rather, you have said that he has a family. Made a prayer that his family is also to be looked after. Nothing.
Can it be taken up on third?
No, not today. This I have a very small memory. I
Okay.
forget it.
I leave it to your lordship.
Yes, Mr. Goswami. It may be dismissed. Why? That is what I asked him. Something more? But Mr. R. Fukan, Learned Counsel for the petitioner, also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate. You are an additional senior government advocate appearing for the respondents. The challenge in the present proceeding is to an order dated 10/8/2016 passed by the respondent authorities imposing upon the petitioner the penalty of removal from service with effect from removal from service on the ground of unauthorized absence after a disciplinary proceeding was held in the matter. The petitioner has also prayed for a direction upon the respondent authorities to accept his application for voluntary retirement. Also, the materials brought on record reveal that the petitioner herein had submitted an application dated 16/4/2016, praying for voluntary retirement from his services due to some unavoidable domestic problem, not lunacy, Mr. Fukan.
Lordship.
Full stop. The respondent authorities, while order dated 10/5/2016, noticed that the petitioner had completed only 17 years, 9 months, 16 days as on 16/4/2016, and after deducting the non-qualifying service of 2 years, 5 months, 12 days. So accordingly, he was found not to have completed 20 years of service for acceptance of his prayer for voluntary retirement. Accordingly, the petitioner was given time to reconcile, 3 months time to reconcile his decision. So, the petitioner having remained unauthorizedly absent, a departmental proceeding being department proceeding number DP number 4/2016 was drawn up against the petitioner. So, the petitioner, it is seen, had participated in the said disciplinary proceeding, and the inquiry officer on conclusion of the inquiry, had submitted his report on 22/7/2016, holding the charge leveled against the petitioner of unauthorized absence to be established. So, accordingly, the disciplinary authority of the petitioner, wide order dated 10/8/2016, impose on consideration of the materials coming on record, proceeded to impose upon the petitioner the penalty of removal from service with effect from 10/8/2016 for his prolonged unauthorized absence from duty and indisciplined conduct. The period of unauthorized absence of the petitioner was directed to be treated as DIES NON dash non apostrophe beta. Also, the period of suspension was regularized by holding that the petitioner would be only entitled to the subsistence allowance already drawn. So, the said order was passed in the month of passed on 10/8/2016. So, the petitioner has instituted the present proceedings after more than 4 years on 23/11/2020 before this court. So, I've heard the learned counsel for the parties and perused the material on record. So, on the ground of the delay occasioning in challenging the penalty as imposed upon the petitioner, this writ petition is liable to be dismissed without any dismissed in limine. So, however, this court has considered the order dated 10/8/2016 on a consideration of the inquiry report brought on record by the petitioner by way of filing an additional affidavit, it is seen that in the inquiry it was established that the petitioner had remained absent for more than 239 days. So, the petitioner was a member of a discipline force, and such conduct on his part is not condonable. So, the petitioner had during the said inquiry is not found to have taken a plea of that the petitioner was suffering from mental ailments. So, the application as submitted by the petitioner for voluntary retirement also indicates that the prayer was so made on account of certain unavoidable domestic problem. Accordingly, the contention of the petitioner in the present writ petition that he was suffering from mental ailments is not established from any material that has been brought on record. So, as noticed herein above, the petitioner being a member of a discipline force, a conduct at the unauthorized absence on his part is not acceptable, and accordingly, the same would demonstrate gross indisciplined conduct on the part of the petitioner herein. Accordingly, this court is of the considered view that the penalty of removal as imposed upon the petitioner by order dated 10/8/2016 would not mandate any interference. Further, the petitioner has in the writ petition not highlighted any infirmity that had arisen in the conduct of the disciplinary proceedings against the petitioner herein. Accordingly, this court would draw a conclusion that the disciplinary proceedings was proceeded against the petitioner in accordance with law. Having drawn the said conclusion, the prayer of the petitioner for a direction upon the respondent authorities for consideration of his case of his application for voluntary retirement is considered. Although the application for voluntary retirement was submitted by the petitioner before he was imposed with the penalty of removal from service, this court finds that on the date the said application was submitted, the petitioner had not completed 20 years of qualifying service. The respondents had intimated the petitioner about the said position via an order dated 10/5/2016. The petitioner in the present proceedings has also not demonstrated that on 16/4/2016, that is the date when the application for voluntary retirement was made by the petitioner herein, he had completed more than 20 years of qualifying service. Accordingly, this court is of the considered view that the petitioner having been removed from his services, his application would not mandate a consideration at present. And further, the action on the part of the respondent authorities in rejecting his application for voluntary retirement on the ground that he had not completed 20 years of qualifying service as on the date of the application is being also not erroneous, would also not mandate any interference. For the discussions made here in view of the discussions made here in above, this court is of the considered view that the present writ petition is devoid of any merit, and accordingly the same stands dismissed. However, there would be no order as to cause.
Obliged, Lords.
I didn't get you. What? You are appearing for?
Or soil conservation department.
Soil conservation is there. When was it closed down?
My lord, closure liability. VRS benefit.
Mr. Counsel, do you know what you are submitting? Have you gone through the orders of this court? What is the order, last order?
Order. I was present, but at the time.
The thing is that the sale progress is unable to process because department has not sent the requisite FOC proposal through FinAssam portal. Have you sent it subsequently? Okay, if you are not in a position to call, get your secretary by 2 o'clock. We'll discuss with the secretary. I only want to know whether you said that the FOC proposal was not sent in the manner required.
FOC proposal so far.
What do they want here? What is the last order then? What is this last order? It appears that in terms 14.2, payment of VRS benefit to the petitioner has been forwarded by the secretary to the Government of Assam Soil Conservation to the Finance Budget Department, 11/2/25, which shall be considered in the next budget session, and payment can be made after approval of the budget for financial year so and so.
In budget session, it was not considered.
Why?
It is because of finance department, my lord. Finance.
Mr.
Let me have that.
No, you have it from here. What is this? Daily some stands are taken. No, today. You go through the orders.
My lord,
Latest position, we'll get it. Let Mr. Nayak, we take it up after some time. You go through the file. Mr. I'm not with anything. The projections made by your respondents before this court cannot be in error. You cannot change that position subsequently. They said they had sent the VRS proposal to you. You come back and sell that this proposal had not come in the manner required. So we could not process this. 2 dates, 2 times judicial time has been wasted. If that is not the stand, why that stand was taken before this court? Just go through it. I may be wrong. You just go through the orders. And you get your instructions when you are paying the amount. We'll have it at 2 o'clock. When the amount of the petitioners will be released.
within this financial year.
No, I don't want that. I want a date. They cannot be put to hang like this. If you can't, ask your secretary to be here at 2. Can you get that instruction? Can you get that instruction, Mr. Counsel? Get it? We'll have it at 2, Mr. You also go through it. He is not trying to say that. Everything, we will go by the orders passed by this court. We'll go by the orders passed by this court. It's passed basing on the projection made by you. Today you come and take a Volta trend. Not by you means by the respondents. We'll have it at 2. You get complete instructions, resolve this issue, come back. Or then we'll pass appropriate orders otherwise.
All right.
Yes, Mr. Ahmed.
This is removal on the allegation that his wife, Ms. Kobina Nath, has a complaint.
Huh.
On that case, he has already been acquitted.
Hmm.
And here, in similar case, Trilok Singh Rawat.
Mr. Ahmed, what is exactly the position? Whether he was a married, then he married the complainant,
No, no.
or he was
the
not
allegation
married,
is
he
not
married
true.
the complainant for the first time.
Allegation is not true, my lord.
I want a statement from you whether the marriage with Kobita
Kobita.
was his first marriage or was his second marriage.
First marriage.
Mr. Ahmed, are you sure what you are saying?
Yes, first marriage, my lord.
That means
Rupi
there was
Das
no marriage before that.
before that.
It
Rupi
is, she
Das.
is only a cousin sister.
Yes, cousin sister.
Okay.
And accordingly, Lordship kindly see the
And Mr. Ahmed, if that is the stage, I'll be dismissing this writ petition with heavy cost. If the statement you made, which is the statement you have made in the writ petition, that you have not married any person other than Kobita, and it is proved to be the contrary, I am dismissing your writ petition with heavy cost.
let me go through it, my lord.
Go through it. If that is the position, I am dismissing your writ petition
Lordship.
not less than 1 lakh. Will not permit such petitioners to be before this court. Suppression of facts. Yes, Mr. Gupta, what do you say?
The inquiry.
I don't want, get the place wherein he had nominated his first wife. That'll do for me. You have made a statement, but get me that material. If you can get it online, this thing, so that page only. You have made a statement in para 24, he has not denied it. Mr. Ahmed, we are taking it up after some time. You go through it.
Yes.
Because there is gross suppression of facts.
Yes.
You go through it.
Yes.
Go through your writ petition. Maybe he has not disclosed that to you, your petition.
Yes, probably.
In his service records, there is Rubinath as his wife. Right? Page 101.
Probably.
101. This is an application made by you taking time for making a reply. And therein you categorically say, I am on process of filing divorce against my second wife, Kobita Nath. The respondents,
Yes. What respondent?
no, that is by you. That is your letter. And then the respondents have, in paragraph, I'll tell you.
Yes. I have seen one.
In paragraph,
Request for extend some days to our
hmm,
against proposed.
but these things have, in paragraph 24, page 88, 89, have said that your service records reveal Rubita Das as your first wife. And in your reply, you have not denied this. So, can you get hold of that paper? Where in there? Get it, hold. We'll have it at 2 o'clock.
My lord, if she is written that, I am helpless, my lord.
And in para 24, they have said in your service records, that cannot be a lie.
Yes, my
And you were acquitted from your criminal case
Yes.
because the prosecution could not bring the army people or the defense force. It was just a doubt. Your luck was good. But that will not bind us from deciding this writ petition against you.
can pass in what?
You mean to say that you have agreed to this? We
Yes.
can pass
My
an
lord,
order.
Yes, I am only wanted disproportionate punishment and that I have given a
Oh, your suppression. That is what it is. I was there. If you had disclosed these facts, but you have suppressed those facts. You have misrepresented.
He has not told me, but.
That is it. That is it. That is it. Let him suffer. Because in your writ petition, your case is, I never married.
Yes, my lord.
That is a suppression. I would have expected the petitioner to be open that yes, this happened. Mistake. Khurshid Alam, everything. The division bench judgment, kindly take a lenient view. We would
Yes,
have.
yes.
We would have, but not in your case. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. H. Gupta, learned CGC appearing for the respondents. The petitioner, by instituting the present writ petition, has assailed an order dated 12/3/2003. That is page
41 for it. Removal date.
order dated 12/3/2001, by which the petitioner was retired from his services on the ground of used unsuitability under Rule 21, CCS bracket conduct rules, read with Rule 7 of the BSF Rules 1969. The petitioner has also presented a challenge to an order dated 29/11/2018, that is at page 59, by which
Reinstatement of service.
his appeal for
This is-
reinstatement in service was rejected. Also, the facts in brief as evident from the projection as made in the writ petition is that the petitioner herein, who was recruited as a constable oblique water carrier in the border security force on 5/1/2008, wide order dated 5/1/2008, had joined his services in such capacity with effect from 14/1/2008. So, the petitioner was thereafter posted to different units of the force, and while he was discharging his duties in the headquarters of the 139 Battalion BSF at Tripura, his wife Kobita Nath had lodged a complaint petition, on 26/10/2012, before the Chief Judicial Magistrate Mangoldoi, inter alia alleging therein that the petitioner was married earlier with another girl, namely Ruby Das. Also, the said complaint was forwarded by the Chief Judicial Magistrate Mangoldoi to the police, and accordingly, Sipajar Police Station case number 254/2012 under section 417/419/493/494/34 IPC was registered. The petitioner in the writ petition has categorically projected that the lady named in the complaint, that is Ruby Das, was actually his sister, and she was a married lady. The petitioner has further, by referring to the orders passed by the learned trial court, acquitting him and his family members from the charge framed against them, has submitted that the earlier marriage of the petitioner not having been established by the prosecution during the trial, the conclusions drawn by the departmental authorities in the matter would not be sustainable, and accordingly, he would be required to be reinstated in service. Also, by interfering with the impugn orders. Mr. A. Ahmed, learned counsel for the petitioner, by reiterating the facts noticed herein above, had contended that the petitioner was not married prior to his marriage, that prior to his marriage with Kobita Nath, the complainant, by Kobita Nath, and accordingly, the conclusions are drawn by the learned by the departmental authorities of the petitioner having violated the provisions of Rule 21 of the CCA conduct rules would not be sustainable. Also, he has further submitted that the said position having been reiterated reiterated in pursuance to the decision rendered in the matter by the learned trial court, the said that the position reiterated, the allegation leveled against the petitioner by the departmental authorities of having committed a second marriage without due permission from the authorities is not sustainable and accordingly the impugned orders would require an interference. Mr. H. Gupta, learned counsel for the petitioner, has disputed the contentions raised by the petitioner herein. He submits that the service records of the petitioner reveal that he had earlier married one Rubita Nath. He submits that the petitioner had wide communication dated 31/10/2012 while seeking an extension of the time granted to him to submit his reply to the inquiry report, to the proposal to impose penalty on him in pursuance to a court of inquiry held in the matter, had stated that had highlighted the reason to be the filing of a divorce against his second wife, Kobita Nath, that is the complainant. Also, he submits that the said position along with the disclosure made in the service records demonstrate that the petitioner herein had contracted a second marriage and accordingly the allegation leveled against him under Rule 21 of violation of Rule 21 of the CCS conduct rules and Rule 7 of the BSF Rules 1969 stands established. Mr. Gupta has submitted that in spite of the said position available on records, the petitioner is found to have suppressed the setbacks in the writ petition. He submits that in the writ petition, the petitioner has only contended that the lady Ruby Das was in fact his cousin and had not married him. The petitioner in the writ petition had contended that the allegation leveled against him under Section 21 of violation of Rule 21 of the CCS conduct rules to be not born, to be perverse. I've heard the learned counsel for the parties and peruse the material available on record. Dismissed. Mr. Ahmed is there. We are not imposing any costs.
Actually, he has suppressed his.
That postmaster. This case is an open and shut case. If you go through the trial court order, the army authorities were not produced as prosecution witnesses. The records were not produced. Call records were not produced. So the court, what will it do? It held he is not guilty. But all the materials are available in court of inquiry. It was established. And my only thing is why the suppression in the writ petition? No cost order cost to law. Yes, Mr. Goswami. No, you were to pay 50% by next month. This is of August. Why not paid?
So for what?
I don't know anything. I don't know anything. This is your undertaking. No. You tell me. You tell me, because this court said Mr. Goswami, learned standing, submits that the respondents are attempting to pay the mentioned money and submits that they will pay they will be able to pay 50% of the remaining amount by next month.
And we are proposing such type
No,
of plan.
there is two part. Full amount you are proposing, 50% you are paying. No, attempt is for the first part, not for the second part. And submits that they will be able to pay 50% of the remaining amount by the next month.
Is it
What is the total amount? By 2, get your instructions. Then it will be interest. Poor people, they are only abiding by this. Your people, my people, they are citizens before this court. We are least bothered. Once you have made a submission, you have to comply.
that submission?
No, you had the order. You have gone through this order. It was passed in your presence and submits that they will be able to pay 50% of the remaining amount. But I'm only on that 50%, not on the full amount. At 2 o'clock.
Uh,
See, it's very easy to say tomorrow. Then do you know how this file? Then a person will have to carry this file again in the evening to my house. Why trouble the registry people?
I have to.
Okay, Wednesday. On the prayer of Mr. J.K. Goswami, Learned Counsel for the appearing for the respond number
2 and 3, Lord.
2 and 3. Registry to list this matter again on Wednesday. 12. So, Mr. Goswami submits that. Thursday. Okay, Thursday. Mr. Goswami submits that he would apprise this court as to whether the 50% amount undertaken to be paid, released to the petitioner, has in fact been released. It is to be noted that in the event the said amount is not released and a cogent reason is not adduced for the purpose other than the lack of funds, this court would consider imposition of adequate interest on the said amount for violation of the undertaken given before this court on 28/8/2025. Mr. Goswami, if you have not released by tomorrow, I'll keep my hands away. And the other part we will consider. Item number 27 to over there.
Hello. Analogous.
We'll take up 27 first.
27.
We'll take up 27 first. Item number 27.
Item file only because of some development occurred.
That's it. That's it. So if we come in your favor in item number 27, we did not consider item number 13. This will do. Now tell me whether a particular AWC is to be attached with X ICDS project or with Y ICDS project. What are the parameters to be considered?
All other
What are the parameters? All others, Mr. That's not of any consequence. What are the parameters to be considered and what is the violation made? These are administrative decisions. If we start interfering with these decisions, how will the government run? Now you tell me, what are the parameters required to be?
my contention is that, my lord.
I
all
only
other-
want to know what are the parameters. That these are the parameters which will determine which AWC will be under which ICDS project. That is your case here. That others have been given to Goripur. Why me to other one? So
Forgot about item number 27, my
you withdraw it, I'll forget it.
my lord.
Okay.
And
Uh,
item number 13, your
We'll consider that. Mr. A. Raman, Learned Counsel for the petitioners, on instruction submits that he be permitted to withdraw the present writ petition. For prayer not being objected to by Mr. D. Nath, Learned Senior Government Advocate, the present writ petition stands dismissed on withdrawal. Now you come to 13. Yes. I can understand village. But in the scheme of the things with regard to Anganwadi worker, Anganwadi helper, supervisor. Supervisor is a state cadre, right? It's a state cadre. It's no longer a contractual engagement or a voluntary service. Once you become a supervisor, you become a member, a civil servant. Anganwadi helper and Anganwadi worker, how can you divorce them from the ICDS project?
No clause.
Fine. That is again by presuming that it would be an ICDS consideration is ICDS per se. If the two Anganwadi centers fall within the same two or even more Anganwadi centers in a revenue village, fall within a particular ICDS project, this notification automatically will apply. Just show me whether it is only the village ICDS we have to, Anganwadi centers we have to consider and not the ICDS project. Just show me that.
Case 45, your lordship. And
45. Yes,
both 9, your lordship.
clause 9.
Promotion shall remain conform to the standards of the same revenue village. As such, an Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion that arises in the center falling in a different revenue village. I am not applying in revenue village, your lordship. Same revenue village claiming for promotion. There is no clause regarding the ICDS that I have to apply within the same and all other criteria have been followed, your lord. They are eligible for promotion.
They are otherwise eligible. Okay. Yes, Mr.
To that first.
Hmm.
Order dated 21/9/2020.
We have seen it. My order. This issue,
Got it. To an extent. Well,
we have got it.
the promotion has to be ICDS wise.
Where did I say that? Hmm.
For submission, lordship will put the repetition at paragraph number 6. In that case, 7, my lord. Second. Here, that the quota as prescribed for that. Finally, lordship may whenever vacancy arises against the vacancies. They were Anganwadi helpers.
Oh, the last line
Yes, madam.
would be so reckon ICDS project wise. 15, 16.
Yes, my lord. 16.
Within an ICDS project. Mr.
Appeal.
What happened in the appeal?
Yes, my lord. Appeal copy I have given. Kindly take read appeal copy. Read appeal 294 of
Hmm.
Single judge has upheld the
Oh,
by the said decision, they have the intra-court appeal. 14, my lord.
hmm. Hmm.
Para 14, my lord. Then everything has to be able to the cadre strength.
Where are you reading that?
Para 14, kindly allow me to
Yes.
appellant as well as the submissions. This court is of the consider Department Government of Assam having them in the vacancy and with prior permission of the director relatable to the cadre strength. CDPO is leading the court is unable to accept the contention of the learned counsel for the appellant that the cadre strength could be bifurcated to mean cadre strength which exists prior.
So the conclusions drawn by this court was not interfered with.
Learned
Or
counsel-
three,
Five, court free.
isolation. It has to be read in the context. Four also. Four, no, five. Five. That is what found favor with the division bench. Yes. Yes.
Respect of petition number 2 and 4 are within the same ICD. Present merger, your lordship.
That we don't know.
That is in the.
Lordship
I-
will,
I'll only go by the
lordship will consider the
order only. The impugn order, if you have something, they can come back. There is no problem.
I mean,
25, that is a director's order. Two and four Debitola.
debitula.
And now they have been merged in some other,
my lord, within the same ICDS was after development. Your lord.
Goripur.
In the, my lord. That is Gauripur Dharmasala ICD,
Dharamtal,
Dharmasala.
Dharmasala.
Respect of petition number 2 and 4.
So in the other case, only petition number 2 and 4 are there. But here you have made a prayer different from
Development occurring. That's why
after even this writ petition. Here the case is that they wanted to come to Dharamsala, Goripur. Have they been brought to Goripur?
the same ICDS project.
Oh, Mr. Counsel,
Yes, your lord.
here you say that these two petitioners, the Anganwadi center they are working in, has to be brought within the Goripur ICDS project, right? And they were said to be working under
Rupsi ICDS project.
Rupsi, both of them Rupsi. So they were not brought under Goripur. They were brought under some other, Golakganj. Huh? So after that, were they again brought back to Goripur?
No, no.
Then-
my lord, I am subject of uh, 2 and 4, my lord.
2 and 4.
2 and 4.
Ah.
They are rightly merged with the Gauripur Dharmasala.
If they are merged, the consequences will follow. We don't know. Have you brought that on record?
Lord, that is in the item number 27, your lord.
Show me. What is the name? What is the name?
Sia Khatu.
So they are not petitioners here. So how do I get to know that they were brought here? Yes, where is it?
It's 30 onwards, your lord. So
30. No,
Right.
show me the exact thing. Asima. Asima. They were under Bagulamari Part 1 Revenue Village. Devitola. So from Devitola, how have you been? You do one thing. You don't press this writ petition for 2 and 4. You make a prayer. We'll allow you to delete those 2.
and 3.
Lordship, may kindly see.
Huh. This recruitment is over. There is an order, interim order. Interim order was passed the other day only.
Yes, sir, that till
Okay.
don't go.
They'll not participate. Yes. When was this shifting taken place? When was it brought to you under the Gauripur ICDS project? When were you brought?
Immediately after
No. After the advertisement or before the advertisement? Then the advertisement will govern whatever it is there. So in future, if something in Gauripur comes out, you will get it. Otherwise, you'll not get. But today, the advertisement, have you challenged the advertisement in this writ petition? Is the advertisement under challenge?
my lord.
Show me. Right.
Page 54, your lordship.
Yes, Mr. Nath. Now, by your action, if they have also come in within that ICDS project, no, not 27, 13, item number 13, 174. They have challenged.
What is their challenge, my lord, in the advertisement?
Their
Yes,
challenge is that it should be village without a DHOS ICDS project.
although we are in the same village, we belong to
So that has to be given. Now, what will happen to the merger now? Because they have been merged subsequently.
In fact, the advertisement was, the process was under. They have already taken the process, my lord.
Interview and all complete.
22, yes, because of the, kindly see the.
And that was disposed of.
Can-
That we got it.
How not for years they came a lot.
No, but you have also not filled up the post. It seems from the order dated 21/9/23. Oh, this is 23, 1 year only. But this is not a new order. This is of 23. Okay. No, they will not. This 27 has been withdrawn.
Yes, withdrawn.
He has withdrawn. So this is gone. This order will pass at 2 o'clock. We'll follow the division bench as well as the single coordinate bench order.
I'll finish also in respect of.
You withdraw. The interim order will go, your risk, we don't know.
Your lordship.
It will have 2000 pass.
Just hang-
We'll vacate the order today only.
I'm obliged.
You need not be here. You can ask your junior to be here. We'll vacate the orders at 2 o'clock.
Lordship, I'm
In this matter,
Item?
item 14, ma'am.
Okay. Yes, Bora.
Affidavit, my lord. Affidavit we have dated from
Just show the original advertisement. From the advertisement, if you can show. That plea you have taken in para 6, 7 and 8. But what about the advertisement? Show me the advertisement.
Page 18, my lord.
18.
Annexure 3.
1-8. Okay. Where is the qualification? Which is the post? Serial number?
First is the dietitian, my lord.
Serial number?
Bottom below, my lord. Point number 7, my lord. Serial number 7.
That is carpenter.
Grade 3, non-technical post, my lord.
Where?
Bottom portion, my lord. Here in 7. Number 7.
Dietitian.
Dietitian. Thereafter, my lord, in next column, my lord, number 2, dresser.
Dresser.
Number 2 is the dresser, my lord. And 36 is the dental technician, my lord.
36. Okay. HSLC or equivalent with 2 years diploma in dental technician course from government recognized university. Now show me that you have this qualification. That means if we have understood it correctly, you must be a higher secondary pass. You may be a MSc also, but you must have a 2-year diploma in dental technician course from government recognized university. Just show me that you have the dental qualification.
My senior will appear.
Timing. We have passed one order at 2 o'clock. Thereafter, we'll take up this call.
Terms of this honorable court, the instruction was sought for, my lord. My case, my lord, here, the SLC also considered my case, my lord. Only because of not having the this particular post, was kept pending, and my list, my name is in the top, my lord. And now, it was in 2022, my lord. SLC considered my case. Then, my lord, in the meantime, my name has been recommended for a grade 4 in the cultural department. And accordingly, my lord, when it was processed, after the process, my lord, abruptly they have come with the cultural department saying that, no, that post already we have filled up. When it was processed, showing the...
Yes, anything to say? Yes, Mr.
My lord, in this regard, honorable court in several occasions called for the instruction to place before this honorable court.
When is the date of death?
Date of death is, my lord, 19/10/2014, man. Then DLC considered it on 15/7/2015.
Just a moment, Mr. Death. Then first consideration DLC 15
7, 2015,
recommended.
Lordship,
Then,
against the 5% quota, my lord.
then,
That recommendation is still enclosed, my lord. It is there,
then 2 times you came before this court.
Lordship.
Hmm.
Then in earlier occasion in 2018, Lord, I have come before this honorable court,
Why did you come?
my lord, since
Many times, Mr. Goswami, earlier, how many times had he come before this court? Once or twice? Once, I suppose.
I have stated, my lord, in para, my lord.
No, once.
Yes.
4646.
Yes,
Then your DLC, then
Yes.
page 30, 33.
Lordship.
That is the High Court order. It was rejected by SLC. Then this court said 6/2/2019 under clause 15,
Yes,
right?
yes.
So then what happened?
Then it was considered by the SLC, my lord.
SLC. You were at serial number 23.
23, and up to 22, they have been appointed. Now, in the remaining list, my name is in the top,
First.
my lord.
Hmm.
And meanwhile, my lord, some of the persons have been appointed, my lord, below me, my lord.
When were they appointed?
One, as per my RTI, my lord, that part, lordship, they have stated in the petition, my lord, this communication, my lord, lordship have a looked at page 48, lordship.
Hmm.
Access is page 48, lordship. Married, lordship.
Okay, got it.
Now, thereafter, my lord, this communication was continued, my lord. 49,
Hmm. But they say now that there is no post.
no post.
Then you have filed an
Now-
additional affidavit.
Yes, my lord, now 7th June 2023,
Hmm.
they have said that there is no post. Now they have come with the post that this post already been filled up.
Hmm.
There is no post.
Where do I get that?
My lord, that part they have stated in their affidavit. My lord.
Affidavit.
And my lord,
Showing no vacant post, para 13.
and
Yes.
my lord, meanwhile, my lord, about 5,000 posts were filled up.
When?
That is
After the SLC.
after the SLC.
But Mr. Chetri, this court had only required your case to be considered under clause 15.
Lordship.
So that order still holds the field. So whatever new posts have come in, we cannot go into that. We'll have to be under clause 15 only. Because that's the order. And you have accepted that. It cannot be now a new appointment in the department itself. How can this court be, when that order is alive, how can this court go and change that? That order would have been in the division bench.
My lord, only I am only confined to that particular their proposal which they have initiated.
That is, this court said,
Consider-
consider his case under 15,
Yes.
clause 15. They have sent it to cultural. Now, cultural says we don't have a post. Be that as it may. Yes, Mr. Goswami.
It was their post. The
But if
post
they have
was
filled it up.
available, but subsequently
Yes,
they have filled up
Mr.
it.
Goswami.
Regard recommendation only.
But you say that you don't have a vacancy,
Yes,
how will
Lordship,
we
yes,
appoint?
Now, Lordship, at this stage, Lordship,
Okay. Mara. Mr. Chetri will pass the orders at after lunch. We have one order to pass. After that, we'll pass the order. Hey, Ruta, dear Bishop Baki.
That part also, my lord, the earlier occasion 18/9/2024, this office memorandum was relied on by the council, my lord. Then this honorable court in order dated 21/7/25 passed the order. Just I'm reading the last line, my lord. Prima facie, this court is of the view that this OM dated 18/9/24 may not be applicable in the facts of the present proceeding, as there is no quarrel that the petitioner upon the due consideration by the SLC was placed at serial number 1 during the relevant period of time, and this appointment was recommended for being made in grade 4 post in the Cultural Affairs Department, which however could not be completed for the reasons which have not been placed before this court. We therefore permit the learned government advocate to complete the instruction and also apprise this court as to the anticipated vacancy, which was reflected in the communication dated 18/11/2020.
Yes, what about this instruction that was required to be called? Last 18/9?
regarding that, Lordship,
No vacancy communicated. You get it by 2. Get it by 2. If not, call your officer, whoever he knows, ask him to apprise you if there is vacancy. Yes or no, Mr. You are A. Roman. A. Roman, learned counsel for the petitioner. A. Roman, huh? Also heard Mr. D. Nath, learned senior government advocate, appearing for the senior government advocate Assam, appearing for the respondents. The petitioners, by way of instituting the present proceeding, have prayed for a direction upon the respondent authorities to consider their case for promotion to the post of Anganwadi worker available in other Anganwadi centers situated within the same revenue village wherein the Anganwadi centers of the petitioners are situated. Also, it is also the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. Also, the petitioners herein are working as Anganwadi helpers in various Anganwadi centers under the control of the operating under the control of the which ICDS centers? 2 ICDS centers are?
ICDS project,
Rupsi ICDS project and
Devitola.
Debitola ICDS projects. The petitioners claim, petitioners have projected that in terms of a notification dated 4/3/2013, the government of Assam in the Social Welfare Department had formulated the guidelines for promotion of Anganwadi helpers to the post of Anganwadi workers situated within the same revenue village but in other Anganwadi centers. The petitioners submit that in their respective revenue villages, there exists more than one Anganwadi center. And accordingly, a vacancy having arisen in the post of Anganwadi worker in one of the Anganwadi centers situated within the revenue village, other than the center wherein the petitioners were serving as Anganwadi helpers, the petitioners had submitted applications for consideration of their cases for such promotion. In terms of the guidelines laid down under wide notification dated 4/3/2013, their cases not being considered, the petitioners had approached this court by way of instituting a writ petition being WPC number
174.
6115/2022, right?
Earlier one.
This court A coordinate bench of this court wide order dated 19/9/2022 noticing the grievances raised by the petitioner, dispose of the said petition, directing the petitioners herein to submit a representation before the Director of Social Welfare Assam, staking their claim for promotion. Also, it is the director of Social Welfare Assam was to dispose of the said representation by passing a recent order. It is to be noted that the posts against which the petitioners were claiming recruitment were put up for were claiming promotion were put up for recruitment by way of an issuance of an advertisement dated 30/8/2022. Also, the Director of Women and Child Development, Assam, wide order dated 13/12/2022 on considering the grievances raised by the petitioner, was pleased to dispose of the representations by holding that the petitioners not being found to be serving under Gauripur ICDS project as Anganwadi helpers and the posts of Anganwadi workers having arisen in Anganwadi centers under the jurisdiction of the Gauripur ICDS project, their claim for such promotion came to be rejected. Full stop. Being aggrieved, the petitioners have instituted the present writ petition. Mr. A. Raman, learned counsel for the petitioners, has submitted that the notification dated 4/3/2013, having mandated that the consideration of the cases of Anganwadi helpers for promotion to the post of Anganwadi workers would be confined to the Anganwadi centers situated within the same village, and the said notification having not specified anything with regard to the Anganwadi centers to belong to be placed under this jurisdiction of the same ICDS project, the case of the petitioners herein was mandated to be considered for promotion before the same was put up for direct recruitment. Also, he submits that the notification dated 4/3/2013, having not made any stipulation that the consideration of the Anganwadi helpers for promotion to the Anganwadi workers would be confined, in addition to the revenue village, to the same ICDS center, ICDS project, the ground as taken, the reason as assigned by the Director of Women and Child Development, wide the order dated 13/12/2022 towards rejecting their claim for such promotion to be perverse, and submits that the same would require an interference from this court. This much. Anything more? Mr. D. Nag, learned counsel for the respondent, has submitted that the Anganwadi centers operating in the state so operate under the jurisdiction of a particular ICDS project. He submits that the recruitment conditions for the various posts figuring in an ICDS project is so governed and is so controlled by the respective ICDS centers. He submits that a person working in a particular ICDS center, more particularly against the post of Anganwadi worker and the Anganwadi helper, cannot have any claim with regard to a post similar in nature and or a higher in rank situated in any other Anganwadi center under the jurisdiction of a different ICDS center. So, in this connection, he has placed reliance on the decision of this court in the case of Asma Khatun versus Commissioner and Secretary to the Government of Assam Social Welfare Department and others, bracketed, order dated, judgment and order dated 8/8/2024 in WPC number 7502/2022, wherein this court had it is submitted that this court in the case of Asma Khatun Supra had held that the promotion in respect of Anganwadi helpers to the post of Anganwadi worker would be considered in the ratio of 75% is to 25%, ICDS project wise. Full stop. He submits that the decision of this court in Asma Khatun was carried upon appeal, and the division bench of this court-wide order dated 16/7/2025 passed in Writ Appeal number 394/2024 Asma Khatun versus Commissioner and Secretary to the Government of Assam Social Welfare Department had dismissed the said writ appeal, thereby upholding the decision of this court in the case of in the single bench in the case of coordinate bench in the case of Asma Khatun. Full stop. I've heard the learned counsel for the parties and perused the materials available on record. The claim of the petitioners in the present petition is for promotion to the post of Anganwadi. The petitioners in the present case are working as Anganwadi helpers in various Anganwadi centers, and they claim promotion. They claim for consideration of their cases for promotion to the post of Anganwadi worker situated in Anganwadi centers other than the centers wherein they are working. First up, the petitioners in this connection have relied upon the guidelines laid down by the authorities for consideration of cases of eligible Anganwadi helpers for promotion to the post of Anganwadi helpers, wide notification dated 4/3/2013. First up, a perusal of the said notification dated 4/3/2013 would bring to the forefront that the promotions in question are confined to Anganwadi centers of the same revenue village, and an Anganwadi helper of one revenue village or ward of a municipality or town committee cannot apply for promotion in the post that arises in centers falling in a different revenue village or ward of a municipality or town committee. In other words, the said promotion is confined to the Anganwadi centers situated within the same revenue village. First of all, the said notification, however, does not stipulate that such Anganwadi centers to also be required to be under the jurisdiction of the same ICDS project. First up, subpara. This court, from the materials brought on record as well as the submissions of the learned counsel for the parties, have noted that the posts of Anganwadi worker as well as Anganwadi helper as created in various Anganwadi centers are controlled by the respective ICDS projects, are controlled by the child development project officers of the ICDS projects wherein such Anganwadi centers have been so, under whose jurisdiction such Anganwadi centers have been so placed. Also, although in the notification dated 4/3/2013, there is no stipulation that the promotion is to be confined only to a particular ICDS project, this court notices that in view of the fact that the Anganwadi helpers and Anganwadi workers, that the posts of Anganwadi helpers and Anganwadi workers are so placed under the jurisdiction of the respective ICDS projects, finds that the promotions from the post of Anganwadi helper to that of Anganwadi worker would also be required to be so considered within the Anganwadi centers placed within the jurisdiction of a particular ICDS project. First up, this court in the case of Asma Khatun (Supra), the coordinate bench of this court in the case of Asma Khatun Supra had drawn the following conclusion. Para 16, 17. So, the said conclusion drawn by this court was on consideration accepted with approval by the division bench of this court in writ appeal number 394/2024. The division bench, the learned division bench on such consideration had drawn the following conclusion. Para 12. Writ appeal. Para 14. 12, 13, 14. So, In view of the above position, comma, it is in view of the above decisions of the coordinate bench as well as the division bench of this court, it is a settled position that the promotions of Anganwadi helpers would be required to be considered within the Anganwadi centers situated in the same village and further to an Anganwadi center operating under a particular ICDS project. Full stop. In view of the above position, this court is of the considered view that the claim of the petitioners made herein for having their respective cases considered for promotion to the post of Anganwadi worker figuring in other Anganwadi centers also situated under the jurisdiction of a different ICDS project than the project under which the petitioners herein are presently working as Anganwadi helper, comma, the said claim would being not maintainable in terms of the said claim is not maintainable both in view of the fact that in view of the structure of the ICDS projects operating in the state as well as the decision of the coordinate bench of this court in the case of Asma Khatun as well approved by the division bench in writ appeal number 394/2024. First of, in view of the above discussion, this court is of the considered view that the claim of the petitioners herein would not be maintainable, and the order passed by and the order dated 13/12/2022 passed by the Director, Women and Child Development Assam would not mandate any interference. Accordingly, the present writ petition is held to be devoid of any merit and the same stands dismissed. Interim orders passed earlier stands vacated. So, with the above observations and directions, the present writ petition stands dismissed.
One more thing, my lord. Liberty may be given in respect of.
Not in this case. That advertisement is already overdue. Let some people come in. You're working. Let some people not working come in. Heard Mr. B. Chetri, learned counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate appearing for the state respondents. The petitioner herein claims, the petitioner by way of instituting the present writ petition has claimed for a direction upon the respondent authorities to appoint him on compassionate grounds in terms of the recommendations made in his case by the state level committee in its meeting held on 13/9/2022. Full stop. The facts in brief requisite for adjudication of the issues arising in the present writ petition is noticed herein under, is noticed as under. Full stop. The petitioner's father, while serving, Mr. Anything more? Nothing? Anything more to be added? If you have anything more, you tell me. The petitioner's father, while serving as a poultry attendant, bracket gate 4, in the establishment of the District Animal Husbandry and Veterinary Officer, Golpara, had died in harness on 19/10/2014. First, thereafter, the petitioner herein submitted an application for appointment on compassionate grounds. First, the district level committee, Golpara,
That compassionate appointment was made.
Submitted an application for appointment on compassionate grounds within the time frame prescribed, full stop. The district level committee in its meeting held on 15/7/2015 considered the application of the petitioner herein, and on finding it to be complying with the requirements so mandated, proceeded to recommend his case for appointment on compassionate grounds against a post identified for the said purpose. The case of the petitioner, the recommendation as made in respect of the petitioner was thereafter forwarded to the state level committee for consideration. So, the state level committee having not considered the case of the petitioner and no communication in this connection having been issued to him, the petitioner had approached this court by way of instituting a writ petition being WPC number 2219/2016. First off, during the pendency of the said proceeding, the respondents had brought to the notice of this court, of the coordinate bench of this court, that the case of the petitioner was considered by the state level committee, and the recommendation as made in his case by the district level committee was rejected on the ground of absence of any vacant post for his appointment. First off, noticing the said position, the coordinate bench of this court, wide order dated 6/2/2019, proceeded to dispose of the said writ petition by remanding back the matter to the state level committee for reconsideration of the case of the petitioner by taking into consideration para 15 of the office memorandum dated 1/6/2015. First up, para 15 of the office memorandum dated 1/6/2015 mandates that if sufficient vacancies are not available in any particular office to accommodate the person in the waiting list for a compassionate appointment, it is open for the administrative department office to take up the matter with other department officers of the government to provide an early appointment on compassionate grounds to those in the waiting list. First off, it is seen that the case of the petitioner was again considered by the state level committee in its meeting held on 13/9/2022. First off, on such consideration, the petitioner was placed at serial number 23 of its recommendations. First off, there being no available vacant posts for accommodating the petitioner within the in the Directorate of Animal Husbandry and Veterinary Assam, the case of the petitioner was placed in serial number was placed in the waiting list, and the authorities were directed to explore as to whether the persons placed in the waiting list, including the petitioner herein, can be accommodated in other departments of the government of Assam. First off, accordingly, the authorities in the Animal Husbandry and Veterinary Department, having noticed a vacancy in the grade 4, a vacancy being available in grade 4 category at the Sodia Cultural Center under the Cultural Affairs Department, Government of Assam, the name of the petitioner was forwarded to the Cultural Affairs Department for appointment against the grade 4 post so denoted to be available. Full stop. The said appointment not having occasioned and the petitioner's grievance being not redressed, the petitioner has instituted the present proceeding. Mr. Chetri, learned counsel for the petitioner, B. Chetri, learned counsel for the petitioner, by referring to the recommendations made in respect of the petitioner by the state level committee, has submitted that the said recommendations were implemented by the respondent authorities in the form of making a recommendation in respect of the petitioner herein to the Cultural Affairs Department for his appointment on compassionate grounds against a post identified for the said purpose. Mr. Chetri submits that person similarly situated and placed in the waiting list of the state level committee, similarly situated like the petitioner and placed in the waiting list by the state level committee, and in whose case also recommendations were made for their appointment on compassionate grounds to other departments other than the Animal Husbandry and Veterinary Department, were accommodated against posts so identified. However, the said benefit was not extended to the petitioner herein. Mr. Chetri has submitted that the respondents in the present proceedings have highlighted that the post against which the case of the petitioner was recommended, was not found to be existing in the Cultural Affairs Department, and accordingly was found to have been filled up in the Cultural Affairs Department, and accordingly the case of the petitioner was not considered for appointment on compassionate grounds. Mr. Chetri submits that the recommendation has made in his favor by the state level committee being implemented by the respondent authorities. The petitioner herein cannot be denied an appointment on compassionate grounds. Full stop. Mr. Chetri has further submitted that there are presently available more than 5,000 posts are available all over Assam, and the posts were put up for a recruitment. Full stop. He submits that 5% of the said posts are mandatorily required to be kept reserved for appointment on compassionate grounds, and the case of the petitioner herein is accordingly required to be so considered. He submits that the eligibility of the petitioner herein being determined by both the district level committee and the state level committee for being appointed on compassionate grounds, denial of the appointment to him is arbitrary, illegal, and discriminatory. First, in the above premises, Mr. Chetri submits that appropriate directions is called upon to be issued to the concerned authorities for appointment of the petitioner on compassionate grounds. Anything more, Mr. Chetri? Per contra, Mr. J.K. Goswami, learned counsel for the respondent, has submitted that the petitioner's case was not considered for appointment on compassionate grounds in the Animal Husbandry and Veterinary Department, on account of the fact that no vacant post for the purpose was available. Full stop. He submits that the said position is not disputed by the petitioner herein. Full stop. Mr. Goswami submits that in terms of the provisions of clause 15 of the office memorandum dated 1/6/2015, the case of the petitioner was forwarded to the Cultural Affairs Department for appointment against a vacant post in the grade 4 category. Full stop. Mr. Goswami submits that although the said step was taken, the appointment could not materialize inasmuch as it was found subsequently that there was no vacant post available for accommodating the petitioner herein on compassionate grounds. For appointing the petitioner herein on compassionate grounds. First off, he submits that the father of the petitioner having died in harness on 19/10/2014, 11 years having lapsed, the immediacy for appointment on compassionate grounds in respect of the petitioner herein has been lost, and accordingly, no direction is called upon to be issued by this court for appointment of the petitioner on compassionate ground. This court has considered the arguments, the submissions made by the learned counsel for the parties, and also perused the materials available on record. The facts noticed herein above pertaining to the consideration made in respect of the petitioner for appointment on compassionate grounds is not disputed. Also, this court notices that the father of the petitioner herein had died in harness on 19/10/2014. Thereafter, the case of the petitioner was duly considered by the district level committee and a recommendation in his favor came to be made. However, the said recommendation on being placed before the state level committee, his case was rejected. Such recommendation came to be rejected on the ground of non-availability of vacant posts to accommodate the petitioner herein. First off, the coordinate bench of this court-wide order dated 6/2/2019, passed in WPC number 46/2018, had remanded the matter back to the state level committee for consideration of this case of the petitioner, specifically under the provisions of para 15 of the notification dated 1/6/2015. It is found that on such reconsideration of the case of the petitioner herein, the state level committee, although did not find him within the zone of consideration for appointment on compassionate grounds in comparison to the vacant post available, the claim of the petitioner was placed in the waiting list, and a recommendation was made for consideration for exploring the fact. A recommendation was made to the authorities of the Animal Husbandry and Veterinary Department for exploring as to whether the case of the appointment of the petitioner on compassionate grounds can be effected in any other departments of the government of Assam. It is seen that in terms of the said recommendation of the state level committee, the authorities in the Animal Husbandry and Veterinary Department had recommended the case of the petitioner to the Cultural Affairs Department for appointment against a vacant grade 4 post, which was held to be available at the relevant point of time. Also, it is seen from the materials available on record that the said post was not available, and accordingly, the proposal recommendation as made in respect of the petitioner for appointment on compassionate grounds against a grade 4 vacant post in the Cultural Affairs Department did not materialize. Full stop.
That point, my lord. Probably it will be helpful for the lordship kindly have a look that their communication,
46.
that communication. Yes, lordship correct. 46 and 48. The basis of this.
Also, this court notices that the recommendation in respect of the petitioner for appointment on compassionate grounds in Cultural Affairs Department was made in pursuance to a communication dated 18/11/2022 issued by the Cultural Affairs Department to the Animal Husbandry and Veterinary Department, wherein one grade 4 post was identified, was held to fall was held to be was demonstrated to be vacant. Full stop. This court, full stop. However, they said appointment however, the recommendation on being made in the favor of the petitioner by the Animal Husbandry Department, the Cultural Affairs Department had not proceeded to appoint the petitioner by taking a plea that the post was no longer vacant. Full stop.
That subsequently it was subsequently it was kind of diverted, this post subsequently.
Either does it has gone not there. Full stop. This court also notices that out of the recommendation made, full stop. This court also notices that persons similarly situated placed in the waiting list by the state level committee along with the petitioner, were accommodated in the Department of Home and Political were appointed in the Home and Political Department, Government of Assam, against the post of AB Constable. Full stop. This court has perused the communication dated 31/23, wherein the said appointment effected in the respect of similarly situated persons has been disclosed. A court on perusal of the said communication finds that the petitioner herein at the relevant point of time was aged about 31 years, and accordingly he was found not eligible for being appointed against the post of AB Constable, and accordingly his case was recommended for appointment against the vacancy in the Cultural Affairs Department against a grade 4 post. Also, the upstart of the above discussion is that the case of the petitioner, although recommended by the concerned authorities, his appointment on compassionate grounds could not materialize. Full stop. This court finds that around 11 years have lapsed since the date of the death of the father of the petitioner herein. Full stop. Considering the long lapse of time occasioning in the matter, and noticing the fact that the petitioner and his family members have sustained without being favored with an appointment, without any member of the family being favored with an appointment on compassionate grounds, this court, by appreciating the fact.
Just for your lordships.
Just a minute. Kelly, by appreciating the fact that compassionate appointment is provided to face to tide over the immediate financial constraints, financial hardships faced by the family of a government employee dying in harness, holds that the immediacy required remediacy that holds that the claim of the petitioner herein for appointment on compassionate grounds had been rendered stale, the immediacy being lost. Yes, Mr.
2025, 0 Super C.
You have given me that.
That para 28 is relevant, madam.
Where is that?
That 28, another case I gave the is judgment ballot before law. Para 28 is relevant for me. It starts from 26. 2001 matter. Court says that no, on this. And in another matter, my lord,
Okay.
another judgment, my lord, I'm relying. That is, my lord, Supreme Court said that even for non-availability of the vacancy, it cannot be rejected. Lots of kindly have it. The last, just I'm marking, my lord, for your lordship. Last part.
Also, at this stage, Mr. Chetri has relied upon the decisions of the Honorable Supreme Court in the case of Mr. Chetri, in support of his submissions, has relied upon the decisions of the Honorable Supreme Court in the case of Canara Bank versus Ajit Kumar. In the case of Nadeem Khan versus State of Madhya Pradesh and others, reported in 2024 0 Supreme bracket SC 1138, and in the case of Canara Bank versus Ajit Kumar GK, reported in 2025 0 Supreme SC 309. So, having drawn the above conclusions, this court, this court, in support of its above conclusions, relies on the decision of the Honorable Supreme Court in the case of State of West Bengal versus Debabrata Tiwari and others, reported in 2023 SSC online SC 219. Edu to me loba WPC liha /2024, order dated 27/11/2020, para 12 to dilue 12 tolot jikhini quoting ase ekhini pura loi loba. Abhishek para 13.
But only
Para 14. Just a moment. Para 14 only. 13, 14 maybe. Also, having drawn the above conclusions, this court would now examine the decisions, would now consider the decisions relied upon by the Honorable Supreme Court, relied upon by the learned counsel for the petitioner. Also, this court finds that the case of the petitioner was wide order dated 6/2/2009, 19 passed by this court, by the coordinate bench of this court in WPC number 4646/2018, directed to be considered only within the provisions of para 15 of the office memorandum dated 1/6/2015. This court finds that the case of the petitioner was duly considered in terms of para 15 of the office memorandum dated 1/6/2015. However, the vacancy against which the case of the petitioner was recommended for appointment on compassionate grounds being not available with the Cultural Affairs Department by the time the matter had matured for his appointment, the appointment on compassionate grounds in respect of the petitioner had not mandated. So, in view of the directions passed by the coordinate bench in WPC number 4646/2018, the case of the petitioner cannot now be considered cannot now be directed to be considered against any other vacancy other than the vacancy covered by para 15 of the notification dated 1/6/2015. The provisions of para 15 having been found to have been complied in respect of the petitioner herein, this court is of the considered view that the decisions of the Honorable Supreme Court in the case of Nadeem Khan Supra and Ajit Kumar GK Supra would not advance the case of the petitioner herein. For the reasons
Well,
as
only-
noticed herein
only-
above, this court is of the considered view that the present writ petition is devoid of any merit, and accordingly the same stands dismissed. However, there would be no address to cost.
My lord, only since lordships has said that to get the instruction from the director. A director is
Good
only
ground-
within the.
A good ground for appeal. A good ground for appeal. I've kept something open for you. You also get me something so that I can be forced to change my view. I want that. Mr. Chetri can do it. I know that. And Mr. Chetri will do it for me.
These poor people, my lord, were filing appeal, all these things.
Mr. Chetri, I am not here to consider one poor man. I am here to consider all the poor in the society.
Yes, my lord, but this compensation and appointment, otherwise.
There has to be a limit.
Yes.
And these cases, Mr. Chetri, you know better. We are here as a judge or a lawyer. We are here with the issue. But when such matters are pending, you think about the hope and aspiration a man brings in. That boy will not try for any other avenue of employment till this is completely closed. This is destroying his life. I've seen it, Mr. Chetri. I've seen it.
Right.
So the earlier we either allow or dismiss, at the earliest, it is better for the petitioner because he knows that this is not there. Otherwise, he will always sit hoping that this will happen. And Mr. Chetri, out of 199 cases, you will find these petitioners not seeking any other employment. They wait for this outcome. And the whole family gets destroyed. And by the time he realizes that it's not happening, it's too late in the day. That is why this court is too strict on this point. That is one of the views. Nothing personal.
That's no, my lord, but these persons, the litigants are only matriculate or this high secondary, they do not have that much of knowledge.
Because Mr. Chetri, whatever you say and do, this is not a matter of appointment right.
That's
There
true,
has to be.
that's
And
true.
if a person survives for 11 years, what is the need for a compassionate appointment?
Otherwise, Supreme Court said that, my lord, that cannot be the ground, but
That
it-
Supreme Court has said
on-
the other way
it-
also.
It has to be decided on
Let's see,
merit.
let's see. In a given case, we'll see. But you get out of this view, get an order from the division bench. I'm ready with you.
But my lord, imaginary, my lord, for the petitioners. My lord. Let us hope for
Thank
the
you.
best.
Sorry. Yes.
May I get the order, that judgment, my lord?
Please. A judgment. Citation to all officers. You take it after. Your junior will take it after some time. He'll have to type it out. Yes. Yes, Mr. Counsel, what do you have to say
Well,
here?
there's item number 19, right?
Yes, yes.
Malaz, I appear on behalf of the petitioner. Malaz, the main
Yes.
counsel here is in some personal difficulty, Malaz, so that's why he could not travel today. Malaz, so I'm requesting a short accommodation. Malaz, may fix it anytime next week, Malaz, as per my lords.
You're not the arguing counsel.
No, Malaz, I'm not the arguing counsel.
What is your right?
Please, Malaz.
What is your right? What is your proposition? What is the law you are
Malaz,
relying?
the issue in this is, Malaz, this person has been working, Malaz, in the department for more than 10 years, Malaz. So
He's
he is
been
seeking
allowed to.
regularization,
He's
Malaz.
been allowed to participate in the recruitment exercise. He will participate. If he comes out satisfactorily, fine. Why a
Malaz,
special thing has to be given to him?
Malaz, I had limited instruction, Malaz, I'm not authorized to ask.
It is submitted that the arguing counsel. Who is the arguing counsel?
Malaz, Mr. Sagar Saxena.
Mr. S. Saxena
Please, Malaz.
is not available on account of certain personal inconvenience. it is prayed that the matter be taken up on, you give me a date,
My lords, any day, my lord, next week.
next week on 19/11/2024. Full stop. Prayer accepted. Register to list this matter again on 19/11/2025.
Grateful, my lords.
I seek time to file a reply on that.
This affidavit was filed in January 6/3/2024. So why time is required?
Each senior is not present,
Huh?
Each council is not present.
Oh, we're not present. Why did you not miss and make a note? We have come reading. Now you satisfy me.
I'm not.
You're a bank employee.
Yes, Your Honor.
Sell me.
Worship, this case, we have preferred petition.
You have the records with you, madam. Why should we not uphold this penalty? You disclose information about the bank accounts.
Yes, the allegation was that, but there is a cross-examine, where
Show me the counterpart. Yes. Which part?
I'm showing you, we have challenged this basically on the chart sheet, that there are
By the allegations leveled against you, admittedly a loss of confidence has occasioned. Once there is a loss of confidence on a
yes,
bank employee, that is the end of the matter. Then
the allegation was
your son introduced you to that man. You then transferred the details. That's the basic allegation.
basic allegation, yes, Your Honor, but
FIR is also attached.
Oh, that means you are relying to dismiss him on the criminal case. Then where is the Caesar memo? Okay, now that you are arguing, you argue. Where is the Caesar memo? What was seized from her bag? Where do I find that? We'll have this on Thursday. Prepare. On the prayer of the Learned Council for the parties, registered to list this matter again on Thursday, 13. No further adjournment. You satisfy me as to how you came to this conclusion that the preponderance of probability, what are the materials? That much only. Okay? If you are relying on the police report, there has to be a Caesar list. You are relying on the Caesar list. Show me that Caesar list. It's not there. No point. You will have to come prepared.
I have studied yesterday.
I studied yesterday night only.
I just studied yesterday.
Come prepared with this point. That is the only way you can get out.
Charge along.
Yes. Yes. What is the case?
Lordship, yeah, matter is conducted by S. Saul, Lordship, Senior Council.
Huh?
Senior Council S. Saul also conducted the matter.
We don't know.
Not well today, Lordship.
Oh, that is not accepted.
Kindly, matter fiction.
No.
Give his admission, Lordship.
Yes. Considered and rejected. Enough. That is enough. When did he fall sick? When did he fall sick? Today.
Lordship, he's not well, Lordship, today.
So earlier morning it was something else. That his mother was not sick.
I will take admission, Lordship. I will not.
Huh?
I will take.
On the prayer of the Learned Council for the petitioner, registered to list this matter again. 13/11/2025.
Lordship, can it be put?
No, this week. No further adjournment. I'll dismiss it for non-prosecution. Otherwise. Even? You want the benefit of Apran Chetia.
And the item 22 is for pension.
But pension, I'll have to regularize you first. You will have to be regularized. You are ad hoc 3F. You did not from 3F become a regular.
I am relying the judgment of Lordship, the Dolly Pujari Lordship.
Dolly Pujari is a different established thing altogether. Therein, the pension was not attached because the institution was not held to be a pensionable institution. Then this court held that that is a pensionable institution, 31 would apply, and accordingly pension was given. Now you tell me, you are only an ad hoc employee.
Yes, Lordship.
Where is your right to receive pension?
Yes, in the Dolly Pujari also, Lordship, the appointment was contractual. And she was also not regularized, Lordship. Lordship, I have annexed the judgment, Lordship. Additional affidavit I have annexed, Lordship.
Okay, show me.
Page 59, Lordship. Judgment.
Where is that? Show me.
Yes, Lord. Page 59, Lordship. Paragraph 5.
Para 5. No, that petitioner was a contractual employee. Show me, where? Where do I get it?
Para 3, Lordship. The appellant was appointed as a language officer under the commission.
This is different. She was a employee of the commission per se. She was a regular employee of the commission. She was promoted also.
Promoted, Lord, but she was
No.
contractual, Lordship.
But the thing is, the commission was not recognized to be a government department, and accordingly, the pension rules was not applicable. This court held that the pension rules are applicable, and it is a part of the government itself. That is how the relief was given.
And in our case, Lordship, the department is pensionable department, Lordship, and the petitioner was.
Now you show me how we will regularize your services. Just make your submissions on that.
Past, Lordship.
And you see that the contention here is that the appellant was holding a post on substantive and permanent basis.
Yes, Lordship.
So you are not holding a post on permanent, substantive and permanent basis.
In this judgment, Lordship, the division bench clearly says that how she was treated as permanent and
Yes.
And this next case, Lordship, when the petitioner is in service, he filed this case, Lordship, for regularization. This case, Lordship, all the departments, in finance, everything, Lordship, every department, Lordship.
They said it was placed before the cabinet.
For regularization.
What happened then? Yes. When will it be finalized? With retrospective effect?
Your Lordship, the
How will you take care of the case of the petitioner herein? Admittedly, he's been working since.
Lordship, initially it was.
Mister, this is not the way you argue. Get the Supreme Court decisions latest of Justice Vikram, Justice Jaggu, and the following judgments. Coming here with Dolly Pujari is not going to take you anywhere.
Short judgment of Supreme Court, Lordship, ad hoc employee, short judgment.
Who? What is the name?
Lordship, the state of Gujarat and others versus Talsibhai.
You get Jaggu. Jaggu and the series thereafter. Yes. Forget pension. We are not even contemplating pension. We are with his regularization. Let him place. When? Friday. Monday. As prayed for by the Learned Counsel for the petitioner, registered to list this matter again on Monday, 17. 2025. Otherwise, it's a very easy case for me to dismiss. So you build up your case. Let him try, Mr. Pujari. It's very easy to dismiss it, but let us see what he does. And my decision is there of the division bench. I'm binding on me now. I have distinguished all these cases in respect of ad hoc teachers of polytechnics and engineering colleges, lecturers. There was a semblance of appointment. Matter is pending in the Supreme Court. I don't know what has happened thereafter. You also place the judgments. Monday we'll.
Your Lordship.
Hmm.
Father applied for my lord, land, my lord, for settlement of.
Yes, what happened?
Father died, my lord. Application was rejected.
Yes, Mr.
Then
Borua, what has
then
happened?
Petitioner filed an application, my lord. Case, my lord, put 38, my lord.
Yes. Your instruction is para 30, page 34. What do you have to say on this? Where is the land policy of 2019? Mr. S.R. Borua, learned counsel for the petitioner, submits that he be granted a week's time to complete his instructions in the matter. Also, prayer accepted, registry to list this matter again on 20/11/2025. No further time. You argue, place it before me.
Basically.
Because this is the first returnable day, I'm not doing anything. Next day we are going ahead. 20. Wait for a day.
Bless me.
It's a good idea. On the next day, bring this with you. Iman, eh, Azi? Mr. Ali, thanks for the inputs you have given. We could understand something. One query. The Jamabundi, if you go look at it at page 46, it is reflected that the dag involves 4 katha, 2 lessa, 4 bigha, 2 katha, 4 lessa, right? Now, before you came in, your predecessors or the interest who were there, their names were incorporated. The names of the clients of Mr. Sahewala was already there. And they were occupying 4 bigha plus land. Now that the predecessors in interest of yours had submitted an application for mutation of their names, maybe by way of inheritance, maybe on any count. Now, was it not required that Mr. Sahewala's client be given an opportunity of hearing?
Not necessarily, because my mutation is by way of inheritance, and that is long before your lordship. And whatever they have got your lordship through mutation, as well as a cell deed also I have.
But see, the 4 bighas land
your
that
lordship.
under that dag is already taken over.
That is later on your lordship.
No, it is in 2011.
Because this Horakanto Deka and the other persons, your lordship 1940. Their forefathers in 1940, they are in position, and that land has been.
Now the doubt that has arisen You already have a injunction from the civil court.
Correctly.
Let the civil court
Decide,
decide.
decide your
Till
lordship.
that time, whatever conclusions are drawn, we will provide, will be subject to the outcome of the civil suit.
That's why your lordship,
You already have a protection.
that is why your lordship, the impugn orders may be stayed and it will be subject to the result. of
We will say that the impugn orders are there. However, we are not interfering with the same in view of the pendency of a civil suit touching upon the issue. These impugn orders would be subject to the outcome of the civil suit. Thus, you already have an injunction order.
Okay.
Yes, Mr. Saiwala. More than that, we cannot do anything.
The owners of Dagna. And
Be that as it may, whether 982 got converted into 1036 and then into what you call that 1396 or 1396 is a separate dark created out and then only consists of 4 bigas, not of 9 bigas. That is a issue which will now decided by the trial court. Why should we go into all these things? Mr. Ali, I think we will make that clarification and close this matter.
With regard to title and possession ownership, your lordship, it is the civil.
Either as it may, but the learned, the authorities below as well as the revenue board had made a factual determination basing on the materials available on record.
Lordship.
Now I am asking you, if that be so, if it is 4 bigas, 1396 is 4 bigas only, 4 bigas is already occupied by them through a sale deed.
Lordship.
And how come after that mutation was granted to them, your predecessors in interest could come in without hearing them?
Lordship, their DAG number 1396, it is my DAG also, your lordship, and that is out of DAG number 982. It contains 9 bigas.
Now, if you agree to that, we will consider
It is
that and make an observation.
Subject to the result of the civil suit.
Done. Done. That naturally would be subject to the civil suit. As a full stop, heard Mr. S. Ali, learned counsel for the petition, also heard Mr. G. N. Sahewala, assisted by Ms. K. Bhattacharya, learned, appearing for the respondent, learned counsel, appearing for the respondent number 3 and 4. Also heard Mr. S.R. Borua, S.R. Borua, learned standing counsel, revenue and disaster manager, appearing for the respondent number 1. The challenge in the present proceeding is to the orders passed, orders dated order dated 3/10/2022 passed by the Assam Board of Revenue in case number 15 RA bracketed K/2022, as well as the order dated 21/12/2021 passed by the Additional Deputy Commissioner Kamrup bracketed M. Full stop. The facts in brief requisite for full stop. The petitioners herein have instituted the present the facts in brief requisite for adjudication of the present issue is noticed as follows. So the petitioners in the writ petition project that they have purchased a plot of land measuring 1 biga 2 kata 18 lessa covered by DAG number 982 bracketed old oblique 1396 bracketed new, comprising of KP Patta number 155 old and 653 new, situated at Revenue Village Korol under Revenue Village Korol in the district of Kamrup bracketed Metro. Also, from the recorded Pattadar, owner and possessor of the land. Full stop. It is further projected that after purchase of the land, she had applied for mutation of her name in the records of right, and the mutation was granted by the circle officer Azara Revenue Circle. Full stop. The writ petition projects certain disputes with regard to the land which is contained in DAG number 1396. Full stop. However, after the mutation in respect of the petitioners herein were granted, the respondents number 2 and 3 herein had instituted proceedings before the Deputy Commissioner Kamrup bracketed M. Guwahati for cancellation of such mutation. Full stop. The additional Deputy Commissioner who had taken up the matter for disposal after hearing the parties to the proceedings had wide order dated 21/12/2021, upheld the prayer of the upheld the claim of the respondents herein and directed for correction of the land records by removing the name of the petitioner herein as well as her predecessors in interest from the land records. Also, being aggrieved, the petitioner herein had assailed the said order before the Assam Board of Revenue by way of instituting a case being case number 15 RA bracketed K oblique 2022. The Board of Revenue by order dated 3/10/2024 upon appreciating the evidences, appreciating the materials coming on record and also after hearing the learned counsel for the parties was pleased to partially allow the appeal and the impugn order and the order passed by the order dated 21/12/2021 passed by the learned Additional Deputy Commissioner Kamrup bracketed M. Guwahati was upheld insofar as it pertains to the cancellation of the petitioner's mutation in respect of DAG number 1396. The learned board, the Assam Revenue Board, however, upheld the restored such mutation in respect of the petitioner's land with regard to DAG number 982. Also, being aggrieved, the petitioner has instituted the present proceeding. The learned counsel for the parties have made their respective submission. However, the parties have also brought to the notice of this court that the petitioner herein has already instituted a civil suit being title suit number 410/2020, therein claiming right title and interest over the suit land as involved in the proceedings before the Additional Deputy Commissioner as well as the Assam Board of Revenue. Also, this court has been further apprised that an order of injunction has been passed by the learned trial court on 22/12/2020, restraining the eviction of the petitioner's herein from the land, in question, and the said suit is presently pending disposal. Also, this court, on perusal of the materials brought on record, finds that the title suit 410/2020, also having raised an issue with regard to right title and interest of the petitioner herein over the suit land, along with other consequential reliefs, this court is of the considered view that the challenge as presented herein by the petitioner with regard to the order dated 3/10/2024 passed by the Assam Board of Revenue in case number 15 RAK oblique 2022, as well as the order dated 21/12/2022 passed by the Additional Deputy Commissioner, Kamrup, Metro Guwahati would not mandate any consideration herein. However, this court provides that the orders dated 21/12/82 passed by the Additional Deputy Commissioner, and the order dated 3/10/2024 passed by the Assam Board of Revenue in case number so and so shall be subject to the outcome of the proceedings in title suit number 410/2021. With the above observations and actions, the present writ petition stands disposed of. Yes. Interim orders passed earlier stand vacated. You already have an injunction, there is no problem.
Please, my lord. In this
Yes,
case,
Mr. Dekar. There is a clarification from the respondent number 3 by way of an affidavit. What do you say on that?
Is that he or the state of acquiring the qualification?
So if that qualification has been wrongly depicted in the certificate, is he at fault? Because there is a clarification.
He is not at fault.
There is a clarification already given. You have a chief boiler
It has
inspector,
to be certified under the boiler rules.
boiler rules.
That certificate is not there.
Okay, fine.
His lordship will look at the date of the certificate, 9th of August. The advertisement says that the last date of acquiring qualification is 30.
But he, in this case, he had completed the course before that.
Maybe, my lord, but the certificate is not there.
So show me that you have a certificate on that day. Where is that requirement?
The requirement, lordship, comes to page 9,
Page 30.
39.
I'll hear you, Mr. Khan. I'll hear you. 39, yes.
Bottom, my lord, cut
Hmm.
off date for reckoning eligibility criteria.
Now, where is that qualification that you must have a certificate to that effect?
Yes, that is at page 31.
Hmm.
At the bottom. Boiler authority of the state boiler competency certificate second class. Yes, diploma in mechanical engineering. So along with boiler competency certificate BCC second class, that admittedly they do not have, or national apprenticeship certificate in boiler attendant under the Apprenticeship Act with due endorsement of equivalence to the second class boiler attendant.
So the last date of this application was?
Last date of application is 22/8.
24. 24.
8 or 22/8. 21/8 is the last date of submission.
And 24. 2024.
24.
And the certificate is dated?
9/8.
9/8.
No, last date of submission is 21/8. Last date of acquiring the qualification is 31/7.
Qualification he had acquired the qualification immediately after completion of the thing. Your certificate is there.
That is my certificate sample, my lord. Can very well certify that he has studied up to class 10 in my school. Last certificate will be issued by the board, my lord. I cannot issue he has completed the training in my Guwahati refinery.
What more requirement is there other than the training?
The certificate will be given by the authority concerned, not by me, my lord. That is why the National Apprenticeship Certificate is issued by the authority, not by me.
What do you say about the respond number 3's affidavit? See, Mr. Deka, in the event the certificate in place of Bachelor of Science cannot be under the apprenticeship, can it be a Bachelor of Science? I got
There
it.
is a mistake, my lord. As per the advertisement, we cannot consider. He will be, if it is corrected, there is no problem in considering him for the next vacancy. But there is a defect in the certificate, my lord.
You mean to say that we are ready, but provided you have your own things in place, or there are others who will be coming in?
We have got nothing against the PD. In fact, we were trying to help them. There is a letter. from
You have
us.
given, but he also projects that the letter was sent in such a manner that the certificate for the reason came to be projected as Bachelor of Science.
Our mistake, my lord.
And where is that requirement that it should be on 31/7?
Page
Where do-
39. Page 39.
Okay. Yes, Mr. Khan. Two queries before you start off. One, whether the completion of the apprenticeship course by itself is the certification that you have the qualification, or a certification is required by the competent authority certifying that you have completed the course.
They have given me the certificate.
No, that is, but they have also stipulated that the final certificate will be by the so-and-so authority. What do you say?
And that was on 9/8.
9/8. This is of 22/24. Okay, fine. You have completed your certification, your course that they have certificate. But the thing would materialize only on the issuance of the certificate of proficiency by the competent authority, which came into being on 9/8/2024. So whether you can be held to be qualified for that before a date you have acquired that certificate. Say in a matriculation, I may be wrong, in a matriculation examination, You have completed the examination sometime in February, March. So you have appeared in the court, the authorities of the school authorities can also certify that Mr. So-and-so has appeared in the matriculation examination and he was not found to be involved in any sort of malpractice. But the certificate would come from the board sometime in July, August. In the meantime, from February to March, can you be said to be a qualified, to have qualified HSLC examination?
Get the point, my lord. So, my lord, will my lord grant me just 2 days time so that I can come and reply on this point? Whatever it is, because this is a new point raised, my lord.
New point, that is the only point.
My lord.
I asked Mr. Decca in a different manner so that I can get something out for him, from him for your benefit. But he is too smart to give me an answer in that
No,
line.
basically, their argument is that there is a cutoff date and whatever certificate we have obtained, whether it is.
Apprenticeship, when are you an apprentice?
Yes.
Whether you are a qualified apprentice on the day you complete the training with them or on the day you are certified to complete.
By the authority.
We'll have it on Thursday. Thursday board hoigol na Budbar. Wednesday. On the prayer of Mr. A.M. Khan, F. Khan, Learned Counsel for the petitioner, registered to list this matter again on Wednesday, 12. Mr. N. Decca, Learned Counsel for the respondents, is present. And Mr. B. Decca. B. Decca and Mr. N. Decca, Learned Counsel for the respondents, are present. You have to get Decca square out of your place now.
My lord.
One Decca is enough. Now you're having Decca square.
Yes.
But the affidavit of this R3 is very, very dicey. You have seen that?
That we have got nothing,
You are holy than thou. You have nothing against them.
we have nothing against them.
But you get
we
it
cannot help
corrected.
them.
But once they say that this is a, okay, fine, we'll hear it. We'll hear it.
Grateful, my lord.
Amount released? Why? Forget it.
My instruction.
Leave encashment cannot be withheld.
Leave encashment, you cannot.
Part of salary.
It's a part of the salary, rightly said. So, until and unless there is a conviction. Now, even if there is a conviction, you can't touch he's already retired. You can't touch his other part. The part pertaining to his service, salaries and all, that is gone. So, leave encashment is a part of that salary only. How can you? That is a right of his when he was serving. Mr. Ahmed, you were placed under suspension?
Not.
No.
No.
You continued in your
Continue,
service this
continue. I need retirement.
he is entitled to gratuity also.
Anyway,
Both. You have filed an affidavit. Where is it? What is that judgment, Mr. Ahmed, you want to rely upon?
this
Yes. Which court? High Court, Supreme Court?
Supreme Court. Supreme Court.
Which is the case?
One is Jagdish Prasad Saini and others, and other is
Jharkhand one. Saini.
and state of Jharkhand was Jitendra.
That is with regard to gratuity.
Gratuity.
Yes. One thing. What is the circular you have? Now, do you have a regulation, a rule, or something wherein you have provided for this? Then the exception to these judgments can be made. Otherwise, no. By way of an executive instruction, you cannot.
Yes.
Okay. On the prayer of your name? A. Atre, Learned Counsel appearing for the respondents number 2 and 3. Mr. A. Atre, Learned Counsel for the respondent number 2 and 3 submits that an affidavit on behalf of the said respondents has been filed on has been filed today. So the same is not on record. Accordingly, registry to list this matter again on 14/11/2025 along with the said affidavit. Will
Can it, after 14 minus?
17/11/2025 along with the said affidavit. So
Leave encashment there.
both you are getting.
Yes, my lord.
But let me just
Yes.
also let him also have a satisfaction that his point was taken. And if you have in your rules, if you have provided for that,
No rule.
nothing doing. Mr. Ahmed is out. Otherwise, no. Okay, fine. Mr. Ahmed will pass the order on Wednesday.
Yes.
Only for 2 days you have to wait. 2 days you have to wait. 17. How much time? 1 hour, 2 hour, 3 hour? Do you admit to this? On the prayer of the learned counsel, none appears for the petitioner on call. Nobody is here. On the prayer of the learned counsel for the standing on a prayer made on behalf of the learned standing council, irrigation department, registry to list this matter again on 19/11/2025. Yes, madam. Why, what instruction? Such clear-cut order of the court is there. She is also one of the female attendant. For that period, 900 rupees, big thing for her. No. No. You have the judgment with you? Any distinguishing factor with regard to the service of the...
He is not.
Okay, a prayer is made on behalf of Mr. D. Upamanyu, learned counsel for the learned standing council, health and family welfare department for an adjournment in the matter on the ground that he is indisposed. Full stop. Prayer accepted. Registry to list this matter again on 20/11/2025. No further adjournment. Only thing, the judgments of this court, it's a judgment in rem following the principle of the central government policy. Whether there is any distinguishing factor. If there is no distinguishing factor, he gets it. 900 rupees only. Come on.
File affidavit, my lord, my proposal.
No affidavit is required.
My lord, my proposal is pending. Only my prayer is that to decide on the basis of my proposal, my lord.
When is the death of the father?
2020, 13,
2013.
13.
12 years.
Proposal is pending.
Where is your proposal pending?
Page 24.
Page 24.
26 is the original, my lord.
This is of 20. Proposal pending for the last 5 years. And the policy says if it is pending for some time, it is not to be considered.
Ashok and they have submitted.
No instruction is required. But Mr. N. Sharma, learned counsel for the petitioner. Also, none. Yes, who is for the APDCL? What is your name? Mr. B. Das, learned standing counsel, learned counsel appears for the respondent number 2 to 5. Also, the present application writ petition has been instituted by the petitioner, praying for a direction upon the respondent authorities for consideration of his case for appointment on compassionate grounds in terms of the scheme in place at the relevant point of time, a scheme of the respondents in place at the relevant point of time. Also, as projected in the writ petition, the father of the petitioner, Romani Kanto Dury, while working as a lineman, bracketed LM, L/M, bracket over, -2, under Chilapotar Electric Subdivision, Dhemaji, had died in harness on 19/3/2013. Also, it is further projected that the petitioner, within a reasonable period of time, had submitted his application for appointment on a reasonable period of time after the demise of his father, had submitted an application for appointment on compassionate ground. The date of making of such application has not been disclosed in the writ petition. Also, it is projected that after the death of the father of the petitioner, the respondent authorities had formulated a scheme in the year 2014 for effecting appointment on compassionate grounds. The Learned Counsel for the petitioner submits that the case of the petitioner is covered by the said scheme of 2014 of the respondent authorities. So, the application submitted by the petitioner herein was forwarded by the Chief Executive Officer, North Lakhimpur Electric Circle, APDCL North Lakhimpur, to the Chief General Manager bracketed HRA bracket over APDCL, via a communication dated 27/2020. So, it is seen that after forwarding of the said application, no further steps. So, it is further projected in the writ petition that after forwarding of the said application, no further steps have been taken by the respondent authorities for considering the case of the petitioner herein. So, the present writ petition, accordingly, the petitioner has instituted the present writ petition. Mr. N. Sharma, Learned Counsel for the respondent, submits that the application submitted by the petitioner having been acknowledged and the same having been forwarded via the communication dated 27/2020 to the competent authority for non-consideration of the same has caused great inconvenience to the petitioner and his family members. It is submitted that the petitioner and his family members are not in a position to sustain themselves without being offered with an appointment on compassionate grounds. So, the Learned Counsel for the respondent submit that the father of the petitioner having died in harness on 19/3/2013, more than 12 years having lapsed since the date of death of the petitioner, of the father of the petitioner herein, no direction is called for to be issued by this court in the matter upon the respondent authorities for consideration of the case of the petitioner for appointment on compassionate ground. So, this court has considered I've heard the Learned Counsel for the parties and also peruse the materials available on record. So, the facts as noticed herein above is not disputed. The father of the petitioner had died in harness on 19/3/2013. So, the materials brought on record reveal that after the death of the father of the petitioner, the pension and pensionary benefits of the petitioner's father was released to him. So, the petitioner herein has projected that he had submitted an application proximate to the time of death of his father. However, such application is found to have been forwarded to the competent authority only via communication dated 27/2020. So, after forwarding of the said application on 27/2020, the petitioner is not found to be diligent in pursuing the matter with pertaining to his appointment on compassionate grounds, and the present writ petition was instituted only on 21/3/2025, that is after lapse of 25 years. So, in view of the fact that in view of the long lapse of time occasioning since the death of the father of the petitioner in harness on 19/3/2023, and also this court finding that the petitioner was not diligent in pursuing his claim for appointment on compassionate grounds after the death of his father, this court is of the view that the immediacy required in the matter of appointment on compassionate grounds is lost in the present case. Also, further, the delay occasioning in the matter, as well as coupled with the fact that the petitioner was not diligent in pursuing his claim for appointment on compassionate grounds, this court is of the considered view that the claim of the petitioner for appointment on compassionate grounds has been rendered stale. So, accordingly, this court is not called upon to issue any direction upon the respondent authorities to now consider the claim of the petitioner herein for appointment on compassionate grounds. Yak disu moi. Govindo, hey, to cases, para 13 manopra negi, pura mahidi tolole. 14, 15, 16, 17, quoting was at a time. With the above of them, dismissed.
Affidavit, my lord, just now.
What is that?
Taken that provision regarding delay and access. Sufficient with that.
What is the ground?
How is that, my lord, at the time of date of the petition? Only on two grounds. Died due to extremist violence while on board duty. There is death of the employee due to accident or mishap while on the board duty.
We are not considering this. Tat likhi diya. The Learned Council for the respondent or jot likhisu. The Learned Council for the respondent has further submitted that at the time of the death of the father of the petitioner, the scheme of 24/2025 for appointment on compassionate grounds was holding the field. And in terms of the said scheme, only a serving employee killed due to extremist violence while on duty, and also or having met with his death due to an accident of mishap while on duty, where the legal hairs of in terms of the the Learned Council for the respondent has further submitted that at the time of death of the father of the petitioner, it was the scheme of 24/2025 for appointment on compassionate ground that was holding the field. Full stop. He submits that under the provisions of the scheme of 24/2025, the legal hairs of a serving employee, legal hairs of the serving employee of the board who had died due to extremist violence or due to an accident or mishap while on duty were only eligible for being considered for appointment on compassionate grounds.
Yeah, file affidavit, I have not go through.
I need not go through. Affidavit, not filed, not required. Not required. Appeal. Appeal only. Yes. Mr. Sharma, you seem to be the main culprit. Respond number 4. What is the seniority position amongst the petitioner and the respond number 6? Who prevented you?
It is in promotion.
We can't help it. The petitioner was promoted in March, 1st of March. The respondent number 6 was promoted in 31/3/2022. Now, if that be so, how can the petitioner be junior?
It is in promotion.
How can you do that?
Stage has been taken. I will clarify all these things.
No, we will consider it at that point of time. He has not challenged it.
He has no challenge, but
So once that promotion has taken ahead, how can you now, for the purpose of promotion, again revert that?
Above the few.
I know it, but there is an order of promotion in respect of both of you. Now, she is senior in terms of that promotion order. It may be bad, it may be good, but that has not been withdrawn.
My lord, on that one, your lordship is-
Have you withdrawn that order of promotion?
that stage has taken.
How can you take it subsequently? No, we are stuck on the date he was promotion. On that date, he was senior. Now we will have to undo that. Thereafter, whatever you want to do, you do. I got it, Mr. Hazarika. That is bad. But on the date of the promotion, this was not there. Mr. D.K. Sharma, as well as Mr. I.A. Hazarika, Learned Councils appearing for the respond number 4 and 6 submits that the affidavit, that the instructions have been received and an affidavit on behalf of the respondents represented by them would be filed on or before. No, a week's thing is gone. Now date.
After 2 weeks.
Any date after 2 weeks. Okay. আজি কিমান 10 তাৰিখ নাই এই 10 তাৰিখ on or before 25/11/2025 registered to list this matter again on 1/12/2025. It is provided that no further opportunity to file an affidavit would be granted to the respondents herein. Miss S. Kemprai, Learned Counsel, appears for the Learned Counsel for the respond number 1 and 2 is present. 1, 2, and 3 is present. Petition? From whom? Before whom? We are not concerned. We are not concerned. We are concerned on that day what has happened. This will be after the writ petition is allowed, your promotion is interfered with. You make a prayer, we will provide if required. But this promotion is done. Because senior most, you cannot hold it. Okay, then we'll hear you. Come, tell me what it is. No, if you are ready, we'll hear you, Mr. Dajorika. No, some more time. I'm sorry. That is for Mr. Sharma to clarify. 7, that is immaterial. That is immaterial. He has got it for 11 months. What is this? Hey, let him have it for 11 months. 6, we are only with 6. Okay. Who is appearing for the respondents here? What is this? You are so badly placed that 2 months salary cannot be released. And you make proposals on the wrong proposals and you make him hang again. What is the claim? February 2016, February 2018. Why have you made a proposal for January 2018 and February 2018? When are you paying him? You said you will be paying him in the month of October. Why it has not been paid? Undertaking is here. No, there is an undertaking. Mr. Arbora. Who is Mr. Arbora? He has made an undertaking that after telephonic instruction that the area salary for the month of February, so and so, along with salary for the month of October 2025. This is an undertaking given. Why have you broken it? No, this is also your instruction only then. So, Mr. Bhattakur, how do you get out of this situation? Pay him. Pay him 5,000. Mr. Girin is looking that money will go to Mr. Girin. He thinks, or I'm not giving it to him. I'm giving it to Mr. Sharma only. Yes, what happened to this undertaking? You have made an undertaking. Don't make undertakings. If you have made, comply with it. Otherwise, this court is not going to step back. On the prayer of Mr. I. Bhattakur, Learned Counsel for the petitioner, registered to list this matter again on 14/11/2025. Mr. Bhattakur shall apprise this court as to why the undertaking given by the respondents and recorded in the order dated 26/9/2025 with regard to payment of arrears of salary to the petitioner was not complied with.
Right.
Ask the officer who has given that undertaking to be ready for a cost. Yes, madam. Now, madam, this reversal from the government had occasioned in March 2025. We are in November 2025. Why? Maybe. Okay. Ms. D. Bora, Learned Council, Ms. D. Bora, Learned Standing Council, Health and Family Welfare Department submits that the up-to-date instruction with regard to the processing of the area claims of the petitioner is not available with her, and she prays that the matter be taken up on 18/11/2025, on which date she shall apprise this court with regard to the status of the processing of the area claim of the petitioner herein. Registry to list this matter again on 18/11/2025. Has been filed. The Learned Council for Duta Ekalage Maribade heard Mr. M.E. Mahmood, Learned Council for the petitioner, also heard Mr. G. Pegu, Learned CGC, appearing in WPC number 4821/2025, and Mr. U.K. Goswami, Learned CGC, appearing in WPC number 4619/2025. Mr. Pegu submits that the affidavit in WPC number 4821/2025 would be filed by Wednesday by 12/11/2025, while Mr. U.K. Goswami submits that the affidavit of the respondents in WPC number 4619/2025 has already been filed today, right? Also, in view of the above, the registry to list this, you will require some time to file a rejoinder. First, on filing of the said affidavits, the petitioner is at liberty to bring on record his rejoinder thereto, if so advised. First, registry to list this matter again on 1/12/2025 for admission. Interim order passed. There is no interim order. It's already, no, interim order is there. No, it's without leave.
That leave
Yeah.
of
So it's continuing.
41.
What is your stand with regard to his absorption, Mr. Goswami?
That is not squarely cover, my lord, because.
How does it cover? Rectangularly, triangularly?
And there is a 60% for the that direct recruitment
And
and
40.
the promotional revenue only of the 40%, my lord. I'll clarify everything before your lordship, my lord.
Who is appearing for the respondents? Yes, why is this money not being paid? Who is appearing for the respondents? Okay, 5. Who is there for the forest department? Get hold of somebody from the forest department, mister. Get hold of somebody.
Kindly peruses the last order dated 15/10/2025.
Toyota Silno. This is the case. The case is decided already. The coordinate bench has taken a pain to elaborately discuss the issues. Only it requires a finality to be given. How can you enhance a penalty without hearing him? This plea is not maintainable. We'll consider the other one with regard to the 3 increments down. But this enhancement, not possible. What do you have to say? Why an affidavit is it? It's a question of law. It's a question of law, you argue. It's It's a question of law. Beautifully taken out by the coordinate bench. How can you? Why not today? Today it was fixed for that only. It was fixed for that only. On the prayer of Ms. A. D. Bora, Learned Counsel for the petitioner, registered to list 85479/2025. This matter again on 24/11/2025. So on the next date of listing, Ms. Bora submits that she will make her submissions in the matter. So, Episode 4330. That is up to you. 4330. What do you say about the other case? Ms. Bora submits that in view of registry to list this matter also on 24/11/2025 along with WPC number 5479/2025. Respondents are at liberty to bring on record record their stand by way of filing an affidavit if so advised.
An interim order in item number 42.
Interim order
Item 42, my lord.
5479. Interim order passed earlier to continue until further orders.
Applied. Deeply approved.
Yes, what is the stand? We'll call you a deputy commissioner, that is better. Because this matter has been adjourned way back on 9/10 with this specific requirement. He is not giving you. Short date. On the prayer of Ms. U. Das, Learned Additional Senior Government Advocate, registered to list this matter again on 21/11/2025. Ms. Das shall complete her instructions and apprise this court with regard to the query raised wide order dated 9/10/2025. $55, $56. No, ठीक है सर.
Friday, Your Lordship.
Then my Saturday and Sunday will go. In one case, it is that he does not have the prescribed. One is age. One is age. And the caste certificate, there is no stipulation with regard to caste. He belongs to so and so, which is recognized as a now. He is a scheduled caste otherwise. If that be so, why an enquiry is not permissible and a provisional appointment? Because he has a certificate. There may be some error. It may not be his fault. But that scheduled caste thing is there. Otherwise, he will not get the certificate. Because it moves through the commission, then it comes here. And what is the other one? 29 years. 31 years.
When I
So what is the certificate produced by him? Same thing, caste.
Not in the prescribed format, Your Lordship. Also filed an IA with regards to the same.
You are fine. There is an interim order. Okay. HUD Learned Counsel for the parties. As agreed to by the Learned Counsel. This is the only issue. As agreed to by the Learned Counsel for the parties, registry to list this matter. Give me a convenient date. 14 Friday would not be possible to hear this matter. On 17. 17, 18, whenever. 18? 17, 17/11/2025. Interim order passed earlier. There is only interim order in, I think, one. Which one?
59. 56 also.
In WPC number 619/2025, wide order dated 7/2/2025 shall stand extended till the next date of listing.
Published.
Yes, what is your instructions? Okay, none appears for the petitioner on call. Registry to, for the ends of justice, registry to list this matter again after 2 weeks on a date to be fixed by it. For some, Ms. Udas and Mr. J. Handick, learned counsels are present representing their respective respondent. Why nobody is there? Why? What is the, by the way, what is the particular patta would be? Eto ghura di dibo de instruction jetu dise. Let's say when it comes back, you place it again. Hmm. $55 also. এনেকা লিখি দিয়া দুটা একেলগে মাৰিবটো entry orders passed earlier to continue till the next date of listing, huh? বাকি ইটো কাটি দিয়া.
Negligible. On payment of pay and
Yes, what happened? I know it went to the treasury officer. What happened
Edited
after that?
lordship, part of
We'll have it after 10 minutes. Get the information. What is this? You have nothing? You have got it?
Yes, lordship.
Oh, payment you got?
Part payment only got
Part
lordship.
payment
lordship is from 1/12/2018 to 2000.
22.
Yes, lordship.
You have got.
Yes, lordship.
So nothing is here.
No, lordship. Earlier amount lordship 1/4/2010 to 30/11/2018 lordship.
Okay. What happened to this, Mr. Ghosh? That is not. Have you challenged that order?
Yes, lordship.
Okay. Mr. Your name?
You.
G.G. Gogoi, learned counsel for the petitioner, submits that the arrears of salary are receivable by the petitioner with effect from 1/12/2018 to 28/2/2022 has been released to him for so. However, he submits that the challenge in the present proceedings to the order dated 1/4/2018 rejecting the claim of the petitioner for arrears salaries with effect from 1/4/2010 to 30/11/2018 would be required to be considered by this court. Full stop. The learned counsel for the Mr. A.K. Ghosh, learned counsel for the respondent, submits that he be given, 2 weeks time to file an affidavit in the matter. Prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed by 3 weeks time.
Be the lordship. No, no, that's. It's regarding.
You want the court to be GM HR of IOC?
No, my lord, that.
Or
that
no, GM would be lower post. Director HR.
My lord, that transfer has been made against the HR policy, my lord. That is my case. So lordship comes to.
See, you were originally in the materials department or contract department. You were taken to the audit department. So then 2 claims you have made here. One is in violation of the thing because you have to be given opportunity to explore other areas, other departments. 2, there is a financial loss occasioning to you. Their reply is 3 promotions given. What is the financial loss? That is, I'm more interested.
Financial loss is there, madam. Lordship, lordship.
Financial loss in terms of salary or something else?
Salary, madam.
Oh, salary. Then it's okay.
Salary, madam.
Then it is okay. Then it is okay. Then it is okay. We'll have to hear it today, may not be possible.
Hello.
When? Everything is ready, only dispose it when. Let us have it on Tuesday next, 18. As agreed to by the Learned Council, Learned Council for the parties submit that the pleadings in the matter has been completed and the matter is ready. And the matter can be taken up for disposal. Accordingly, registry to list this matter again on Uthore, 18/11/2025 for admissions. On that day, we will finish it off.
My lord, that may be passing the order. They must have been made for disposal.
If it comes to me, there is no required. How can I ask another court
No.
to? Then? If it comes to me, I am ready. Today also I am ready, but time.
Today, my lord, he is not ready, my lord.
No, no, I am.
Today, he is not
Mr.
ready.
Kolita is always ready.
Obliged, my lord.
But you also address this court about the court's power
Yes, my lord.
to pass orders, posting.
Yes, my lord. Yes, my lord. They
So
are,
tomorrow,
that-
this court will be also be required to pass orders of posting in all government departments.
but there is a policy. They have violated their own
Policy is subject to their convenience.
Oh, my lord,
6.4.
it has to be maintained.
Deputation 2 years. You were there for 3 years. So they have been send you back to the parent department. Okay, fine.
Obliged.
This matter has to go back. What's up? But Mr. N.K. Sharma, Learned Counsel for the petitioner, also heard Mr. A. Chandran, Learned Senior Government Advocate, appearing for the respondents. 1, 2, 3, and 4. Also, the materials brought on record reflect that the present writ petition pertains, the issue arising in the present writ petition pertains to the Itanagar bench of this court. Also, the present writ petition, while being permitted to be moved and filed before the principal bench, it was also stipulated that the present case be transferred to the Itanagar bench after opening of the court on expiry of the vacation, that is after 2025. So, in view of the above position, a registry to transfer the records of the present writ petition to the Itanagar bench of this High Court immediately. Do you want me to fix a date for appearance there? No need. Interim order passed earlier to continue till the next date of listing before the Itanagar bench of this court. Same next order, huh? Same order. 61 also same order. What was it? Pinky is in. Order kita ঠিক করলাম।
Non-appearance, I am extremely
Which
sorry.
one, Mr.?
Yes, 57th.
He is in. Oh, that Nepal Chandra Dhar.
Yes.
Okay, Mr. H.R.A. Chaudhary, Learned Counsel for the petitioner, also heard Ms. Udas, Learned Senior Government Advocate, Additional Senior Government Advocate, and Mr. J. Hendick, Learned Senior Government Advocate, and Mr. J. Hendick, Learned Standing Counsel, SC, Standing Counsel, Revenue and Disaster Management Department. Ms. Das submits that she has received the instructions in pursuance to the directions passed by this court. So accordingly, registry to list this matter again on when it will be convenient to you.
Urgent matter, my lord, because
When it will be convenient to you.
any day, my lord. Any-
On 18/11/2025. We'll consider on that.
Obliged.
And Ms. Das also disclosed to Mr. Chaudhary what is that essence of that. Give a copy, please. That will be better. You go through that.
Obliged.
Huh?
2015. This thing is second step upon the newly implemented respondent number 5. The last order that is published.
Who is that? Respond number 5. It's that Staff Selection
My
Commission.
lord.
Okay.
Leader ethical.
Mr. Kayal, you appear. But you have filed appeals before them. You inform the staff selection authority? No, please do that. Otherwise, we'll have to ask the registry to have him arrested and brought here. But can we pass that order? Why this or notices are not being served? Seen the office note dated 18/9/2025, which reveals that the service report upon respond number 5 is not complete. First up, the steps in the matter was taken on 22/4/2025. First up. Now, the tracking report will also not be there 3 months per. Petitioner is directed to take fresh steps for service of notice upon the respond number 5. Steps within 2 working days from today. Mr. S.C. Cal, Learned Counsel, appearing for the other respondents, is also requested to inform the respondent number 5 about the pendency of the present proceedings. First up, the petitioner is also at liberty to implead the present incumbents in place, present incumbents holding the posts who has retired all 1 to 4. Against the present incumbents, if so advised. Full stop. Registry to list this matter again after 4 weeks on a date to be fixed by it. You get that thing done, otherwise we'll work out something. Mr. Cal, use your good office also. Yes. Yes.
It is, isn't it? So
Yes.
This is the calculation, man.
Calculation is for them. But why are you not releasing?
My lord, as per my instruction, my lord.
Principal amount is.
interest part was also paid, my lord.
What? How did you calculate that interest? The interest, as per the order, is from the date it was due till the date of payment. Both of you sit and break your head and tell me.
My lord, it was, the interest was as per prevailing bank rate, but they have imposed 2.7. That's a different cause of action again. I'm not, my lord, complaining about that, but even 2.7 also, my lord, 10 lakhs is due, my lord, 10 lakhs odd. Very simple, my lord.
This is by you. Where is your calculation? Amount clear means with interest, bank interest. Okay, you give me that. Your DECA, you have A DECA. Mr. A DECA, Learned Counsel for the respondent, submit that the dues receivable by the petitioner, the principal amount receivable by the petitioner along with interest in terms of the directions passed by this court has already been released to the petitioner. The said position is disputed by Mr. P. Mohanto, Learned Counsel for the petitioner. First up, Mr. A. Deka submits that he would place on record on the next date the calculation sheet with regard to the determination of the dues receivable by the petitioner as made by the respondents. So accordingly, registry to list this matter again after 2 weeks. 2 weeks on a date to be fixed by it.
Date if it's possible.
Come, we make a mention.
I'll make it.
Now you have got the elephant. It's only the rope that you want. We will get it. Don't worry. None has appeared for the respondent on call. This court notices that the petitioner hearing was required to take steps for take steps for service of notice upon the respondent number 4. However, the office note dated 10/10/2025 reveals that no such steps have been taken. As there is no representation on behalf of the petitioner and also noticing that the petitioner has defaulted in taking steps in the matter, the present writ petition stands dismissed for non-prosecution. Mr. S. Borua and Mr. I.A. Bhattakur, Learned Counsels, are present representing their respective respondents.
Respondent number C, my lord, still has been taken and
Huh?
He has appeared, my lord, as per number 3.
Right.
Only see the payer, my lord, page number 20,
Hmm.
claiming some salary and my lord, provident fund.
Hmm.
1 and 2 is my lord, private.
1 and 2 is a private limited company. Assam Petroleum Limited. It's a government company. Huh? Pure.
My lord.
Pure private.
Registered under the company sector, my lord.
Oh,
My lord, court already
how is this maintainable?
The
I
11th
thought that that is a government company. Yes, how is this maintainable?
That is publicly doing public duty and under the IOC, my lord. And government.
They may be doing anything, but are they a authority within the meaning of Article 12 or 26? What is it? Show me, Mr. Sinha.
There, my lord, but government share is there, my lord, in this.
Government share?
No comment, sir.
No government share.
Come after 2 weeks, my lord.
No. Today. Satisfy me.
Observe 11-6, kindly see the order 11-6 of
That I did not see. 11.6?
take instruction from the mayor.
11.6? There is no order.
Order like that, probably.
Yes. How is this a private limited company and we want me to interfere with this? Huh? It's only the respond number 1 and 2 who is to pay you, not the others.
No, man.
Yes.
Then
Provident fund, my lord.
I was thinking that this is a government company. That's why I was asking you. Yes. On the prayer of Mr. B. Sinha, learned counsel for the petitioner, registry to list this matter again on Kundina Pari. Ekhopta. 18/11/2025. Mr. Your full name? R. Hazarika, learned counsel for the petitioner, has raised a question of maintainability of the writ petition, and Mr. B.P. Sinha has submitted that he will place his submissions in the matter. Respond number 1 and 2. Mr. B. Chakraborty, S.K. Chakraborty appears for the learned counsel for the respond number 3 is present. He is the umpire.
49. It is your lordship.
Registry to list this matter after disposal of, give me a writ appeal number.
7256 of 2020.
Writ appeal number. Writ appeals are pending. What is this then?
We were directed to implead
This is compassionate appointment. Your case was rejected because of that 3 years
Yes, your lordship.
criteria.
Yes, sir.
Writ appeals are pending. What is that? Give me a number. Anybody, Mr. Huh? 25th. Registry to, as prayed for by the learned counsel for the petitioner, registry to list this matter again after. Registry to list this matter again on 2/12/2025. Respond number 1 still in office? Is respond number 1 still in office? Registry to list this matter before any other bench without me. My client, I can't. Was my client.
Technically.
You make a mention. Yes, Mr. Purkhaista, what do you say?
My lord, we need some more time. 6 weeks time was granted, my lord. So one extension is required, my lord. Only limited period.
3 months, my lord. Because my client.
We are getting on.
But it's a very old thing. Heard Mr. A.K. Sahiwala, learned counsel for the applicant. Also heard Mr. B. Purkhaista, learned counsel appearing for the respondent number 2. for the respondent number 2. Also, the present application has been instituted by the applicants praying for extension of time for compliance with the directions passed by this court wide order dated 3/9/2025 in WPC number 4154/2025. Also, the applicants have paid for extension of time by 3 months for compliance of the said directions. Also, I've heard the learned counsel for the parties and also perused the materials brought on record. Also, although the learned counsel for the respondent has objected to the grant of extension of time to the applicants in the matter. Also, however, considering the fact that it is the projection made that the processing, although made, could not be taken to its logical conclusion in as much as the records of the service records of the petitioner have to be traced out, and the same would require some further time. So, considering the contentions raised in the present interlocutory application and also the objection raised by the learned counsel for the respondent, this court extends the time limit for the outer time limit fixed by this court wide order dated 3/9/2025 or 3/9/2025 in WPC number 4154/2025 for compliance of the directions passed therein by another 2 months. Also, from today. Also, the respondents shall comply with the directions passed by this court wide said order dated 3/9/2025 within the period of 2 months from today. So, with the above observations and directions, the present interlocutory application stands disposed of.
Grateful.
Yes, are you from the village or from outside? Coverage area. How do you say that? No, how do you say that you are there? You were there. And why she is outside? Why is she outside?
No, Lordship.
Page?
Kindly another
No, today. Okay, I'm fixing it. Why should we go into all these things? You go before the director, file an appeal. Director will find out who is where, who is not where. This court is not called upon to decide whether you are insider or she is outsider. Okay? Heard Mr.
M.U. Mondal.
M.U. Mondal, learned counsel for the petitioner. Also heard Mr. R. Islam, learned counsel appearing for the respondent number 7. Also, Miss, what is your name? Also heard Miss Ardas, learned standing counsel, appearing for Miss B. Bhuya. Appearing on behalf of Miss B. Bhuya, learned standing counsel, the BTC. Appearing for the respondents number 2, 3, 4, 5, and 6. 6 is also. And 7, Miss Arla Islama. So, the petitioner, by way of instituting the present writ petition, has assailed the selection and appointment of the respondent number 4 as Anganwadi worker in Singimari Gomat over Anganwadi Center. Also, the petitioner contends that the respondent number 6 herein was not entitled to be selected and appointed as Anganwadi worker for Singimari Gomat Anganwadi Center in as much as she resides beyond the coverage area of the said Anganwadi Center. Also, have you submitted any representation? Also, the Mr. R. Islam, learned counsel for the respondent, disputes the said position and submits that the selection of the petitioner was made by the respondent authorities after due verification of his residential status. Full stop. In view of the rival contentions of the learned counsel for the parties, a disputed question of fact having arisen in this matter, this court is of the considered view that the same would not be permitted, would not consider, this court is of the considered view that the same would not be permissible to be so decided basing on the affidavits filed by the parties to the proceeding. Full stop. Accordingly, this court is of the considered view that the determination, that the claim of the petitioner herein is to be, that the contentions raised in the present writ petition, that the issue arising in the present writ petition would be required to be considered by the district, by the departmental authorities. Who would be the authority? No, who appoints?
CDPO.
Where is the appointment order?
CDPO.
And the approval given by? Full stop. Accordingly, the petitioner is granted liberty to appear to file a representation raising his claims with regard to the ineligibility of the respondent number 67 herein for being appointed as Anganwadi worker of Singimari Gomat Anganwadi Center before the joint director. Joint Director, Women and Child Development, BTC, within a period of 30 days from today. On receipt of such application, such representation from the petitioner herein, the Joint Director, so-and-so, Child and Women Development, BTC, shall fix a date for hearing and shall schedule a date for hearing and issue notices in the matter to the respondent number 6 and others concerned. Full stop. Thereafter, on hearing the petitioner and the respondent number 6 along with the departmental officials, the joint director so-and-so shall dispose of the representation filed by the petitioner herein by way of a speaking order. The selection and appointment of the respondent number 7 shall be subject to such further orders, such orders that would now be passed by the joint director so-and-so upon hearing the parties to the proceeding, as well as upon hearing the parties to the proceeding. So, with the above observations and directions, present writ petition stands disposed of. 7-5, no, it is 7 of us. Huh? Yeah.
In the meantime, Lordship.
We will see on Friday. Apply your mind. We'll see on Wednesday, we will do that. Give him a copy also.
12th.
Okay, 12th. Then, because they are also. Yes. Yes, Mr. Sinha.
Yes, my lord.
As agreed to by the Learned Council for the parties registered Friday. We'll finish it off on that.
Yeah, my lord.
Yes. Why are you keeping this man hanging like this? Expose you first, the authority cleared. You wanted an ex post facto. That has been given. Now why not the payment? On the prayer of Mr. I.A. Bothakur, Learned Counsel, on 19, Mr. Bothakur shall apprise us with regard to
Medical reimbursement.
of the petitioner hearing.